So the vehicle won't be on the slope, it'll be down in where buses park.
That's correct.
Maybe not on the other side of that gate, but there's a front half of the sally port.
That's right.
Down in there.
Yes.
Okay.
Yes. And then that would ensure that the court reporter could take down anything that was necessary. And I would suggest to the court that that the experience be videotaped and perhaps made a part of the record, just in the event that anything occurs. And we've got a person available, if the defense has no objection. It would be Mr. Rico Dollar, who would just merely serve as a videographer for the experience. I would ask that the court allow the jurors to sit in the front or the rear passenger seats, if they so choose. The seats from the time that the vehicle was taken into the custody of the DA's office and looked at by Mr. Knox, the seat was returned to as close to the original position based on the measurements that were done by APD as possible. And they have not been moved since that time, to include when Mr. Ross Gardner from the defense also viewed the vehicle. And with respect to number 4, I would ask the court to allow the jury view to occur in the state's case in chief. And so I think that's my response to the jury view. And then there's one more short issue I'll bring up after that's unrelated.
Okay. You were describing a layout where Ms. Weaver and I and defense would be standing in one place. Where?
And the state.
Oh, and the state.
And the state.
Okay.
We're all kind of because we're situated here.
Okay. We would be in some area where we could see and hear what's going on, but not in the way of the jurors.
That's correct.
Okay. Ms. Weaver, I don't know how portable your equipment is. You wouldn't need your computer down there. There would just need to be a means for you to take down what was said, if anything. There ought not to be anything said, but you need to be down there in case someone blurts something out, and at least a record is made of it. Does some part of your equipment travel like that?
Yeah.
Great. Okay. Who from the defense wants to weigh in on the jury view? Sorry. Good morning.
Good morning, Judge. I hope you had a good vacation. Good morning, ladies and gentlemen. Judge, I want to start with, it sounds to me like we're talking about a jury view from the point, from the perspective that it is going down. However, I want to lodge an objection to the jury view, period. So I want to start from that perspective.
And you should. I haven't decided one way or the other. I wanted to understand some of the logistics, because if it couldn't be made to happen, it didn't really matter what people thought about it. It wasn't going to happen. But it sounds like logistically it could. But let's start at the beginning.
Yeah, logistically, I'm confident it can. But let me again move in sort of a in seriatim fashion. As I understand it, and I'm relying on, among other things, a case called Jordan versus the State at 247 Georgia 328, in which the Georgia Supreme Court distinguishes between evidentiary views and scene views. So I think the first thing we have to make a decision about is whether, if this is going to be allowed, it's going to be an evidentiary view or a scene view. Now, one of the main things logistically that I think would impede either view would be the fact that there is no dowel through the back of the seat. Both sides' experts relate that trajectory to what may or may not have happened in the back seat of the vehicle. The vehicle will not have a trajectory, a dowel rod through it, and if it doesn't have a dowel rod through it, then it is a mere scene, and I don't think it's going to have that much value. We've seen a mock-up. We've seen pictures of the inside. We have seen a laser four-dimensional turntable version of that. So the idea of seeing it, I don't think, without the dowel, doesn't add significantly to the case. And if you say, okay, we'll do that, then it is a pure scene view, not necessarily an evidentiary view. And a scene view is not evidence. That's number one. So I would object to it on that basis because I do not think it is truly representative of the scene, as it were. And therefore, if an individual juror gets in or gets out, it has no evidentiary value in that regard. Now, it may, with regard to the spatial limitations of the back seat. That means each individual juror is going to have to get in, close the door, but without the dowel, you can't tell the arm movements.
But the dowel wouldn't be evidence. I mean, the vehicle didn't have a dowel in it at the time of the incident. You would be modifying the scene. If both sides agree, let's have a dowel in there, then let's have a dowel in there.
No, I understand that, but without the dowel, the fact that you're sitting in the back seat and the fact of any particular limitations really doesn't have any substantive value, because the dowel gives the trajectory and gives the scene its evidentiary value. I don't think there's any question that the bullet went through the back of the seat. The question is how and under what circumstances and under what trajectory. So I don't think a dowelless view has any substantive value. So that's number one, and that would be our objection to the jury view, quad jury view.
Do you oppose inserting a dowel?
I don't know the answer to that.
Okay. Are you thinking about that?
I'm thinking about it, but probably so. I think that changes the dynamic of the whole thing, like you said. The car didn't have a dowel in it, and nobody had flashlights where they could look around, and this was at night. So whether or not you have flashlights going into the vehicle or flashlights to look in the vehicle, again, I think substantively changes the interior view. So I object we object to the use of the flashlights in that regard. I don't necessarily have any problem with the media being present, because I think it is part of the trial, any more than we had objections to the media at the start of the case.
What is your understanding of what it means to be an evidentiary view? What are the consequences? Because the only thing I could tell from reading Jordan is that Mr. McIver better be there if we were classifying it as an evidentiary view. Better practice would be to have him there even if it were a mere scene view, but that's about all I could tell. And of course Mr. McIver will be there, so if we call it an evidentiary view, a potato view, I don't know if it really matters so long as your client is able to see and hear what you're seeing and hearing while it goes on.
And I recognize that this weekend. I'm going through it over this past week, and I'm thinking, okay, you can call it whatever you want. One way, though, it's substantive evidence, and the other way, courts have charged that it's not evidence in the case, although you can use it to make determinations. Now, how that doesn't make it evidence, I'm with you. Okay. I do not understand the distinction, but there is a subtle distinction. One, it is in fact evidence and it's substantive. One, the courts have said, well, a jury view of the scene is not evidence. So, I mean, if it's not evidence, then I don't guess either side can argue it. You know what I mean?
Yeah, I wondered if it was a way to say the case because the defendant didn't go to the scene. Well, we're just not going to call it an evidentiary view, but who knows? We'll have the defendant present if we do this.
At any rate, I'm starting from the proposition that I don't think it's fair and I don't think it's adjusted, and I think the lighting and the conditions are different. Secondly, I know that we'll all work, but I want to make sure before the jury gets there, if we're going to do it, that the positions are as close to what the positions were when the incident took place. And, you know, some of the original scene photographs from the processing that was done by APD can give us a good indication and I particularly want to direct the court and the state to pictures 2871, 2872, and
those numbers don't mean as much. That's a different numbering system.
It's the internal numbering system that the CSI, the crime scene folks, used, and that they are, I believe, admitted into evidence, but it's probably easy to look it up that way. I mean, we just want to make sure.
Sure.
There was a measurement from the back of the seat to the front of the back seat, but without the wine bottle, of course. And I guess we need to see make sure that the dimensions are as close to that as possible if we do it. And I would rather do it at the end of the defense's case, because then we've got both the state's experts and the defense experts talking about their evaluation of the interior of the vehicle. And in that regard, they would have the benefit of both expert testimonies, and then they can see the vehicle, and if you can allow it, and then be able to use it in the best form possible.
Okay. Anything else on the view? No. Oh, all right. Mr. Rucker, you said you had another matter you wanted to take up.
Yes, just very quickly. If the court recalls, and by the way, I kind of anticipated the Dow position, and so we had already reached out to crime scene technician Trowlett, who has testified previously that he's the person who inserted the Dow, and he's available should that become necessary based on the court's ruling. The other issue I wanted to flag for the court is for Dr. Marty Sellers. The court had indicated that perhaps it might be necessary, I don't know if it still is, to maybe talk to him outside the presence of the jurors. And so I just wanted to raise that to the court's attention because we didn't bring that up first thing this morning.
Okay. I think it is appropriate and just restarting the processes of 2 weeks ago. But one of the concerns that Mr. Samuel had raised in connection with this was, did Dr. Sellers reach out to you all because of having followed this case since it began, meaning, since trial began, which is a different posture than what you or Mr. Abate or someone was theorizing. No. He was relaying to the state in his interviews his thoughts and reactions to media coverage back close in time to the incident. So back in 2016, not, I was watching AJC.com in 2018, and so I reached out to you all. I think that needs to be explored because it creates issues, rule of sequestration, etc. And I need to work through what the consequences, if any, ought to be if what played out was Dr. Sellers was watching recent actual coverage of trial as opposed to remembering what he saw or heard, things he saw or heard many months ago. So we should do that. Is Dr. Sellers someone you'd want to call this morning?
Possibly late.
Okay. So So we can do that now, or we can do that when we take a morning break. I'll leave that up to you. Okay. So we'll take a slightly longer than usual morning break so that you all get a little break as well. In terms of the jury view, I'm inclined to allow it, but I think it makes more sense to have the jury look at it after they've heard from the defense expert as well. So I don't think it would be today. I would ask both sides to confer about whether they want the dowel in there or not, because if you do, you need to agree on who's putting it in there and be comfortable with how it looks once it's in there. I appreciate Mr. Harvey's perspective that perhaps it's a richer experience for jurors if it's in there because it shows trajectory. I disagree with his assessment that it is of no evidentiary value if there's no dowel in there. I think being in there with the door closed provides a perspective that was not achievable despite the many different iterations the state presented during the course of its case in chief. But I do think it makes the most sense for the jurors to have heard from Mr. Gardner as well. It sounds like he will be called during the defense case. So they're not thinking, oh, wait a minute, I was just in the car and I can't. I think that should be at the end, the jury view. So hopefully that doesn't scuttle your plans too much. But let's have the two sides talk about dowel, dowelless or doweled view of the vehicle. It's not a final ruling that will do it, but my inclination is that it would be of evidentiary value to the jurors. It's certainly relevant, and it could be set up in a way that closely approximates the conditions. But this will also give, it could be that the defense wants Mr. Gardner to have one last chance to look at how the seats are set up right now. I respect the state's contention that through Mr. Knox, they did their level best to get things into the same position minus the wine bottle. So that's where we are with jury view. Dr. Sellers, we can explore during the morning break. Anything else from the state?
No, I had the truck transported over here this morning, so it is probably downstairs now if during the break. If you want to maybe have Mr. Gardner come over and perhaps look at it, that would be fine.
Okay, I'll let you guys work through that.
Yeah, just let everybody know.
Okay, I don't know about Mr. Gardner's availability. The exhibits have returned, so I saw them brought in. I don't know where they are now, but they're in the courtroom.
Can I make one more observation before we, or make one more request? My understanding is that Investigator Griffin will be the state's first witness today.
Okay.
And I anticipate it's going to be another Detective Smith type direct examination. That is, boy, you work for the DA's office. What did you do when you got the case? I don't know whether her course of conduct is an issue in the case. And just to spend the next however long Mr. Rucker takes her through, and then what did you do, and then what did you do, has any evidentiary value since we're not attacking the state's investigation. In fact, as I told you before, the tables are turned, and it's a little bit difficult for me to be on that side of the ball. But that's what I anticipate is going to happen again. And what did you do next, and who did you talk to next? So
you can ask leading questions if you want.
And maybe you can, because I don't know whether there is any there other than what did you do next, and I don't have any real objection to that. If that's the case, though, I don't understand the relevance of that. So I do want to make a motion in limine that if that's the only purpose, if there is some other purpose, chain of custody, I gathered X, Y, or Z, I can understand that.
Okay.
But if it's just, what did you do next, I do have an objection to that.
Okay. Mr. Rucker, Mr. Harvey makes a couple fair points there. Tell me your brief sketch of what you think Investigator Griffin would be talking about. My perspective is, while the jurors have been away for a while, I don't know how uplifting it will be for them if they're going to hear yet another version of there were lots of guns at the ranch, there was a nice apartment that was laid out in a certain way. I mean, I suspect they remember those kinds of points. I know that Investigator Griffin touched the case in many, many, many different ways. What are you envisioning? Doesn't need to be an exhaustive list, because you may have literally a checklist of, we've got to make sure we lock in this and that. But if it's the whole soup to nuts, I share Mr. Harvey's concern about it either being cumulative or not relevant / they'll stipulate that, in fact, Mr. Hyde handed over firearms to the state, etc. It was a different witness, but the kind of thing we could work through efficiently. What are you envisioning?
And of course, we were sensitive to the fact that, the jurors, I don't think, would be interested in having a recap on every single thing that Investigator Griffin did. But there are just a few particular topic areas that I think Mr. Abadi, who will take Ms. Griffin, will hone in on and specifically identify. It won't be a let's go chronologically, like what did you do on Tuesday and what did you do Wednesday. It's not going to be anything like that at all. And the anticipation was, I'll just share with you, was to kind of culminate with the fact that she has been the person who has kind of maintained the custody and the control of the vehicle since that time. And so then she would have laid the foundation for the jury view. And then so
she should still do that if you think that makes, rather than calling her again. I mean, if you lay that foundation now, it's not like they can, well, it's stale now. The objection that was a good chain of custody for Monday the 9th, but not Thursday the 12th.
Right.
And I don't anticipate that kind of objection, especially with the vehicle.
Right.
Well, I just think, I know it's come up in a couple of jury questions.
Sure.
And so I think that they want to know, like, where's it been, who's had it, and that kind of thing. And so.
Well, that's reassuring. It's not going to be, okay, and then on the next day, and I appreciate why that was done by both sides with Detective Smith.
Right.
But he played structurally a different role. By the time Investigator Griffin is the lead, if you will, on it, APD is largely phased out of the
Correct.
investigation.
That's right.
Okay. Well, I think that was a helpful observation from Mr. Harvey, and I'll be keyed into that if things drag on a little bit too much. Anything else from the defense before we get the jurors in here? No. Oh, okay. Then if the jurors are ready, we're ready. Which fits with the trial because there was the anonymous person who would be before it didn't miss it.
That was good. I told him about that.
All rise for the jury. All jurors are present and accounted for, Judge.
You all can be seated. Welcome back. It's great to see you all. Some of you got haircuts. I got a little bit of a haircut too. Just want to look fresh for you all. We've got a Masters jersey on, the right color, no less, the green. I hope you all enjoyed your time away. We kept you waiting there in the jury room a little bit, so you get a little anxious, and absence makes the heart grow fonder. We were working through a couple matters that we needed to, so we could proceed efficiently this week. Appreciate you all coming back. You all hopefully got a call on Friday from someone from my team, just reminding you that we still have some outstanding business, and we do. I'm sure you remember clearly the state is still presenting its case, and we are going to continue with the state's presentation. Maybe when we break for lunch today, you can give me a sense as to how late you guys want to go each day, but we will keep pressing on. The state did forecast that it envisions resting sometime soon this week, and then we'll need to work through a bunch of legal matters that occur naturally and automatically once the state rests, and we'll figure out what we're going to do after that. But until then, it's the same process. The state will call witnesses, direct exam, the defense will have a chance to conduct cross-examination, and then, of course, if you all have any questions, you'll write them down. And if they are appropriate questions, they'll be posed to the witness. And if anything comes up where you need a break, just do what you used to do. Wave your hand, get Deputy Murphy's attention. Just you this week? Are we going to have Kane joining us, or what do we know?
Not sure, Judge.
Okay, well, we're happy you're here today. All right, and with that, Mr. Abate, you would call the state's next witness.
Thank you, Judge. The state will call Investigator John Griffin.
Do you swear on the affirm that the testimony you should give the court today will be the truth, the whole truth, and nothing but the truth to help you God?
I do.
Yes, ma'am. Get as close to the mic as you can, Investigator. For the purposes of the court's record, please state and spell your name.
Yes. Investigator Jonna Griffin, that's JOHNNA GRIFFIN.
Good morning, Investigator Griffin.
Good morning.
Could
Good morning.
you turn to the jury and introduce yourself and let them know where you are employed?
Yes, I'm employed with the Fulton County District Attorney's Office.
And how long have you worked with the District Attorney's Office?
10 years now.
And tell the jury a little bit about your educational background.
I attended Georgia State University on a volleyball, basketball scholarship, and I received my bachelor's in psychology.
And prior to working at the Fulton County District Attorney's Office, how were you employed?
The Fulton County Police Department.
And how long were you there?
10 years again.
And in those 10 years, where were you assigned?
Yes, I started out as an officer on the streets, and then I was promoted to detective. So I investigated homicides, crimes against women and children, robberies, missing persons, and then I was promoted as sergeant over investigations in that area.
And you said you had been with the District Attorney's Office for 10 years. Where are you currently assigned now?
Yes, now I'm the Deputy Chief of Investigations, and I supervise the Major Case Division. And we handle all the homicides that we receive from the different agencies within Fulton County. We have about 43 investigators, and I have a chief who's above me.
Now, as the Deputy Chief, other than supervision, what are some of your job roles and responsibilities?
I also assist the chief investigator with other responsibilities and duties.
And are you assigned to any particular attorney in the major case unit?
Right now, Clint Rucker.
And what is the major case unit? Why don't you come through what that is?
So all the homicides within Fulton County, which could be from North Fulton to South Fulton, we receive the cases from the lead detectives. that investigated those particular homicides, and then we take those cases and we do and conduct independent investigations.
Now, when you say independent investigations, is the Fulton County District Attorney's Office an independent agency from the Atlanta Police Department or any other police departments within the jurisdiction of Fulton County?
Yes, that is correct.
Okay. And are there times that the two agencies here, the Atlanta Police Department and the Fulton County District Attorney's Office, that they coordinate or work together in an investigation?
Yes, that happens.
And when doing that, does the police department have to follow any recommendations that the district attorney's office recommends?
They do not.
And if the Atlanta Police Department or any police agency was to recommend that the DA do something, does the district attorney's office, are they required or obligated to follow those recommendations?
Not required. No.
Now, can you tell the jury how you got involved with this case, the state of Georgia versus Claude McIver?
Yes, the initial lead investigator for this case was Investigator Terry Jackson. She left our agency and went to the DeKalb County District Attorney's Office. And then I was assigned to this case March the 31st of 2017.
And is that when you also became the deputy chief of the major case unit?
That's correct.
Now, in this case, through your investigation and, I guess, review of the documents, was there any coordination between the Atlanta Police Department and the District Attorney's Office?
Very little.
And is it common, based on your 20-plus years in law enforcement, that after the District Attorney's Office receives a case, that charges are enhanced, added, modified?
Yeah, let me object to that. The charges and any commentary about charges and makes decisions and how it's done is irrelevant and prejudicial.
Your Honor, I respectfully disagree as to the relevance due to the fact from prior testimony from Investigator Smith, the defense, as well as the state elicited.
No, the defense did not.
Before we get too much back and forth, if you want to ask questions along this line of whether, because the police charge next to DA's office is bound by that, I'll allow that. But as to the thought process behind what the right charge is or something like that, we need to stay away from that.
Yes, Your Honor, that wasn't my intention. My question was, is it common when a case comes in that charges change based upon the district attorney's investigation?
Okay, I'll allow that.
So you can answer Investigator Griffin.
Yes, it is very common.
And did that occur in this case?
It did.
Same thing.
So let's stay away from specifics. The jury has heard what it recalls from Detective Smith about what he did. The jury has the indictment, and if during closing arguments folks want to talk about whether there were changes and whatnot, that's fine, but I don't think this is the right witness to explore that.
Yes, Judge. Now, when you initially started working on the case, can you tell the jury the first things that you did to begin your investigation?
Yes, I reviewed the formal report from Detective Darren Smith from the Atlanta Police Department. After that, I reviewed notes from Investigator Terry Jackson. I saw the tasks that she fulfilled.
And about how long did it take you to review the documents from the Atlanta Police Department as well as from the previous investigator on the case, Mr. Terry Jackson?
About 2 or 3 weeks.
Now, as part of your investigation, you referenced that Investigator Jackson takes the notes. Do you also take detailed notes of the steps that you take throughout your investigation?
Yes, I just document what I've done and different tasks that I fulfilled.
And do you interview, or do you take part in the interview of witnesses?
Yes,
And are those interviews audio or video recorded?
they are.
And if, in an instance where you don't have the ability to do that, do you take notes about those interviews?
Yes, I write summaries as to what that particular witness told me or what the interview was about.
Okay. Now, after you reviewed the documents that had occurred before you, what was the first thing you did in your initial part of the true investigation?
Yes, I began looking into the backgrounds of the defendant and Mrs. McIver, where they worked, family dynamics, who they were affiliated with. And then I started to proceed towards the elements of the crime in that night.
And did many of the steps you took in your initial part of your investigation center around things not done by the Atlanta Police Department?
And again, let me object to that question. It's precisely what I raised earlier.
I'm remembering what you raised earlier to be related, but a little different than that. I'll allow that question. My understanding was we weren't going to march through everything, and I'm not saying you've begun to do that, but if you want to repeat the question for the witness, I'll allow it.
Did many of the things that you did, the initial part of your investigation, center around things not done by members of the Atlanta Police Department?
Yes, they did.
Okay. And did you request or subpoena documents related to the defendant as well as the victim?
I did.
And what kind of documents were you requesting or subpoenaing?
Financial documents and any other documents that would give me any more information about the defendant or Mrs. McIver, the victim.
Did you interview close friends of both the defendant as well as the victim?
Yes, I did.
As well as employees employed at both the defendant's place of employment and the victim's place of employment?
Yes, I did.
Did you have an opportunity to drive the route that was taken that evening?
I did. I did it about 3 times.
And did you also participate in the execution of search warrants?
I did.
Now, can you tell the jury how many search warrants that you participated in?
I completed 4.
Excuse me, the number of search warrants. How is that relevant to anything? And unless we're doing chain of custody, and unless we're going someplace in particular, the judicial imprimatur of a search warrant, I think, is more prejudicial and probative at this particular point in a generic form.
Okay.
I can ask a different question.
I'm okay with that question as long as, per your representation, then you're not diving deep to say, let's talk about each one and everything that was recovered in each one, because that's not what I understood was going to be happening. But if you want an answer to how many were you involved in obtaining, I'm all right with that.
Yeah, thank you.
Okay.
So how many searches were you a part of?
4 search warrants.
And can you briefly tell the jury where those took place?
Yes, the first one was at the Harold Hudson Law Firm in Buckhead.
And again, Judge, just saying where a search warrant was executed, again, it puts a judicial imprimatur on it without anything in particular. I did 500 search warrants. So what?
Well, I think that I'm not going to get into what the so what is, but based on our discussion this morning, I understand there to be a so what that I think makes the inquiry relevant at the high level that we're going through this. If we start to get specific, we'll need to revisit that. So you can continue.
I forgot.
So the first search, Harold Hudson's office.
And I guess can you tell the jury why a a search of Mr. Hudson's law firm occurred?
We were looking for
Stop.
Judge, I mean, can we come to sidebar?
Well, we can in a second if we need this.
Okay.
What I think is an appropriate question is, what were you looking for? Now, that is a version of why. I think that's relevant, and I'd allow that. If we need a sidebar to discuss why you shouldn't be able to ask what was the object of the search at location X, we can have that sidebar. I think that's relevant, and I think I would allow you to ask that as to the 4 searches that we've heard the investigator reference. If you want a sidebar on that, we can have that. If you want to preserve something and we can discuss it at a break, we can do that as well. I'm happy either way.
I think is limited. In this trial, and so I want to reiterate that that question was specifically course of conduct.
Well, I think Mr. Abate's explanation for one reason why he's asking it resonated more as course of conduct, but it was relayed to me before the jury got in here as to another reason as to why this is being explored, and I believe that continues to justify these questions for the time being.
Okay.
All right. So
instead of why, I'll ask a very similar question. What were you looking for?
a second will,
And how long did that search take?
about 3 hours.
And through your search of Mr. Hudson's office, were you able to locate a second will or a will subsequent from 2006 of Ms. Diane McIver?
I was not able to locate the second will.
Did you also, as part of that search, search Mr. Hudson's residence?
I did.
And at that residence, were you able to locate a subsequent will in 2006?
No.
Now you said you did 4 searches. Where did the second search occur?
The second search occurred at the Buckhead Condo on Kingsborough Road. And that's where the defendant and Ms. McIver resided. And that was on April the 14th, 2017.
And generally before all the searches occurred, were videos or were the conditions of the areas documented prior to the search?
Yes.
And were photographs taken as well?
Yes, and video.
And during the search or how long did the search of the Buckhead condo take?
Approximately 4 hours.
And during that search, did you locate Ms. McIver's safe in her closet?
I did.
And were you able to gain access to it?
Yes.
And did you find a second will in that safe?
I did not.
And before you gained access in April 2017, did the defendant have access to it?
Yes.
Excuse me. That's
you might need to lay a little foundation before she could be doing something other than speculating.
Okay. I was trying to follow the streamlined approach versus the not ask a whole lot of questions about the searches. So
Life is a long and winding road.
So I will ask some more questions about the safe. Based on so you said you gained access to the safe.
Yes.
And prior to gaining access to the safe, had you interviewed witnesses concerning Mr. McIver's access to the safe at the Buckhead condo?
Yes, I did.
And when did those interviews occur before your search of the condo and the search of the safe in 2017?
Yes, they did.
And based on your investigation, was the defendant residing in the Buckhead condo prior to your search of the April 2017 search?
Yes, he was.
And was he living there immediately after the incident occurred on September 25th of 2016?
Yes.
And based on your investigation, did Mr. McIver have access to the safe prior to your searching it?
Mine.
Did I answer the question?
Same objection. It's based on.
Sure, sustained.
Now, from the search of the condo on Kingsborough, were any items of evidentiary value seized?
And can I object to the question? Any items of evidentiary value?
I'll rephrase the question. Was anything seized from the Buckhead condo?
Yes.
So sustained, and I'll rephrase the question. Okay.
Yes.
Okay. And what was seized generally from the Buckhead condo?
Can I speak with Mr. Lester?
Sure.
From that search, what was seized from the condo?
Numerous boxes, banker boxes filled with documents, financial documents, and other documents related to the scope of our search is what we thought at the time.
And do you remember about how many?
About 20 to 25 boxes.
And when the search was completed, was the condo in the same condition as it was found generally?
It was.
And what was the next search you participated in?
Yes, well, at the condo also, with the boxes that we seized, we also seized some digital media as well. Forgot to mention that. Apple iPad and a hard drive and a computer. And that concluded that search for the condo.
Okay. And the subsequent search was where?
Yes, at the Putnam County Ranch in Eatonton, Georgia. And that occurred on April the 19th, 2017.
And did you follow the same procedures that you described to the jury with that search?
I did.
Was anything seized from the Putnam County Ranch?
Was not.
And were pictures taken?
There were.
Did you also search a storage unit here in DeKalb County?
I did. The same date as the condo, April the 14th. It was the public storage in Brookhaven. And it was where Mrs. McIver and her business partner with DRS Investment shared a storage unit.
And from that search, did you seize anything?
Yes, we seized 2 banker boxes from that location.
And after you seized the items from the searches that you just described to the jury, where did you place those items?
They were securely placed in our evidence room here at the Fulton County District Attorney's Office.
And were those items that you've described, the documents as well as the hard drives and other electronic devices, were they reviewed by an independent team of lawyers?
They were.
And can you tell the jury why?
To ensure that we did not receive any privileged information or attorney-client privileged information, only documents that pertain to the scope of the search that was indicated in my search warrant. So that team served that purpose.
And did the team of lawyers review all the documents and the items that were received during those searches?
They did.
And was a second will located from the review of those documents?
No, it was not.
Now, I know you said that you had interviewed several individuals from the Tory company. Did you investigate about events that occurred when Mr. McIver came to the establishment on September 22nd of 2016?
I did.
And from those interviews, who did you interview?
I interviewed Gail Meadows, Elaine Williams. They were administrators there. I also interviewed Jay Grover, Ken Rickard, Angie Brooks, and I also interviewed Billy Corey himself and 2 other former employees of the Corey U.S. Enterprise, which was Miss Donna DeGroot and Rachel Stiles.
And from the interviews, did the individuals who saw Mr. McIver on the 22nd describe his demeanor or conduct? Now tell me what they said after they described the demeanor or conduct.
Yes, they described it to me.
Now, to your knowledge, had anyone from the Atlanta Police Department spoken to members of the Corey company about those events on the 22nd?
Once again, that would call for hearsay as well.
I can move on.
Okay.
Now, you talked about your visit to the ranch in Putnam County for the execution of the search warrant. Did you make any additional trips to the Putnam County ranch?
Yes, I went to Putnam County and I went to the ranch about 3 times as well.
And did you speak to individuals who came in contact with the defendant and Ms. McIver throughout the weekend, beginning on the evening of September 23rd of 2016 to September 25th of 2016?
Yes, I did.
And did you speak to Tanner McKinney and Miss Samantha Watson?
Yes, I did.
And did Mr. McKinney describe to you any interaction he had with the defendant?
And that calls for a hearsay response, even if it's just yes or no.
I can rephrase the question.
Okay.
Now, were the interviews that you did with Samantha and Mr. Tanner, were they audio recorded?
Yes, they were.
Okay. And were they at the ranch on Sunday, September 25th of 2016?
Same objection. We heard from them.
I understand that we did.
Sorry. Cut that, same objection.
All right. I understand the objection too.
And I can move on. I also
Okay.
understand the objection.
Okay.
Does that help?
Great. We'll move on.
Did you have the opportunity to also interview Mr. Craig Stringer?
Yes, I did.
Okay. And as well as Miss Danny Jo Carter?
Yes.
And did you have an opportunity to visit the golf courses at Reynolds Plantation?
I did not. I did assign another investigator to go to Reynolds Plantation.
And based on your investigation on September 25th of 2016, where did I'll ask a better question. Did you have an opportunity to go to the Longhorns in Condo?
Yes.
And did you speak with Jonathan Moore and Isabel Williamson?
Yes, I did.
Williams, excuse me. Okay. And through your review of the documents from APD as well as from Investigator Terry Jackson, did you see a receipt from the Longhorns from Conner from that night?
Yes.
And based on your review of that document and your investigation and interviews with Ms. Williams as well as Mr. Moore about approximately what time, or were you able to determine the time that the McIvers and Ms. Danny Jo Carter left the Longhorns location?
Same objection.
If you want to key it off the receipt, which is something in evidence, you can do that.
Have we received the evidence?
The evidence is here. I can't promise you that it's in numerical order or anything, but it is in several boxes right there.
I will move on and come back to it.
Okay.
Now, do you know how the defendant and Danny Jo Carter and Ms. McIver left, or what they were traveling on that evening?
Yes.
Again, everything the investigator knows comes from somebody else. So anything she knows is per se hearsay.
I'll ask 4 other questions to get to where I'm trying to go.
Okay. Yeah, I don't think that it's fair to say everything, but much.
No, I agree, and that was a little bit overstated, and I apologize.
Did you have the opportunity to view or examine the 2013 Ford Ranch expedition?
Yes, I did.
Or King Ranch expedition, yes?
Yes.
And where is that located today?
Yes, it is also in our evidence facility secured with the Fulton County District Attorney's Office.
And has it been in that location since the district attorney's receipt of it?
Yes, since we received it.
Now, you said you traveled the route that was taken on September 25th several times?
Yes, about 3.
And as a law enforcement officer for 10 years prior to being with the district attorney's office, did you have any experience or have the opportunity to go to the Edgewood area?
Yes, I have.
And how long have you, or where do you live? What area do you live in?
South Fulton.
Okay. And through your living in South Fulton, close to the city of Atlanta, have you also had any familiarity with the Edgewood exit and area?
I have.
Okay. And in those, I guess, times that you have been in that area, have you seen a large amount of homeless people under the underpass?
Yeah, let me object to that. I think as relevant. And her experience is essentially her opinion. Her opinion is irrelevant and more prejudicial and probative, and under the same circumstances, not under the same circumstances as the circumstances here. So I'm objecting to that. I will object to that question.
You have objected to this question. I think it's a fair objection. If you want to explore further with this witness as to whether she could discuss that area in a way that's more germane to this case, I'll let you do that.
Okay. Through your, I guess, experience of being in that area, have you been down there at night?
I have.
Okay. And have you been in the area of the underpass in the evening?
I have.
Okay. After 10 o'clock?
Yes.
Okay. And in those times, in the times that you also drove the route, were any of those times in the evening?
Yes.
And through your prior experience with the Edgewood underpass, as well as the times that you drove the route in the evening, did you see a large amount of homeless people?
I did not.
Same objection. I don't think it is an appropriate subject that this officer's personal experience on an unknown number of occasions at an unknown time, at an unknown date, is relevant testimony to the night of September 25th, 2016.
Noted. Overruled. She can answer the question.
Any change?
No, I have not.
Now, also, as part of your investigation, did you speak to homeowners and business owners in that area?
I did not, but I did assign an investigator to go out for that purpose in that area.
Now, do you remember when the district attorney's office received the King Ranch expedition?
Yes, it was February I'm not sure the actual date, but it was in 2017.
And how many times would you say that you have had an opportunity to view or examine that vehicle?
About 7 times.
And in the times that you have done that, were you able to determine if the vehicle had a navigation system?
Yes.
And were you able to determine if the vehicle had Bluetooth capability?
Yes, I was.
Okay. And did you actually turn the car on?
I did.
And did you test the navigation system?
I did.
And when you had the car on, were you able to determine if a cell phone or telephone had ever been paired with the Bluetooth in the vehicle?
Yes.
And who did that vehicle belong to?
The vehicle was registered to the defendant, Claude Lee McIver III.
Now, as part of the times that you viewed or examined the vehicle, was anybody with you?
Yes, on different occasions.
And were you present when Michael Knox or Carl Roan looked at the vehicle?
Yes.
Okay. And who is Carl Roan?
He is a firearms expert.
And did he examine the SUV?
Yes, he did.
And did he cut into an area of the front seat as part of his examination?
Are we talking about Rome? Can I come to Sidebar?
Sure. Were we blinding you guys again? Sorry about that. They did the trial last week. They must not have cared about their jurors in the same way they cared about me. I don't know how they did it. They finished that trial in 1 week or 2. Just saying. Okay, you were asking a question about Mr. Rome. If you
Yes.
want to, just so we close the loop, I don't know
Yes.
if there was the objection.
I believe the question was, did Mr. Roan cut into a small area of the front seat?
He did the front passenger seat, yes.
And did it all alter the route or the track of the projectile?
Well, wait, unless we have some expertise in that.
Yeah, so that one, I will.
I'll ask you a different question. Did it cut into the bullet hole in the front seat?
It did not. It was surrounded.
And did Mr. Knox, did he do the same examinations that Mr. Roan did?
He did.
And why did Mr. Knox do that?
Okay, again, Mr. Knox testified, and Mr. Knox can testify about why he did or why he didn't do something, I think, object to the question.
I gather.
I'll ask a different question.
Okay.
Why did the district attorney's office ask Mr. Knox to do examinations that Carl Roan had already done?
Same objection. Same objection.
How is it relevant to what the jury's working through that your office may have had two different people do some more about the car?
I guess it's not.
Okay. The next question.
Well, can we approach Your Honor for a quick second?
Sure.
Now, Investigator Griffin, did you also have an opportunity to interview individuals from Emory University?
Yes, I did.
Now, did you interview a large number of personnel from Emory University?
Yes, I did. Quite a
And
bit.
do you remember how many people you had interviewed from Emory University?
I think it was 27.
Okay. And you said you received Detective Smith's report?
I did.
And how many people did he interview from Emory University?
I saw one with Dr. Hardy, Susan Hardy.
And you interviewed 27?
Yes, sir.
Did you have an opportunity to interview a Dr. Celine Shagler?
I did.
Okay. And was that interview that you did, or took part in, was it audio recorded?
Yes.
Okay. And through or during that interview, do you recall Dr. Shagler saying that the defendant had told her that the victim, Ms. McIver, was holding the gun when it went off?
Yes, I do.
Now, in addition to the report that you received from Detective Smith, did you also receive any audio or video recordings that he did?
I did.
You did?
Yes.
And from those audio recordings, did you have one from Ms. Gail Meadows or Ms. Elaine Williams?
No.
Now, through your time, or I guess the several times that you drove the route, was on that route the intersections of 12th and Piedmont and 14th and Piedmont Road?
Yes.
And are both of those locations located within Fulton County?
Both of them are.
Also, as part of your investigation, did you go or did you interview Miss Wendy Edson?
Yes, I did.
Did you physically go down to her funeral home in Condo, Georgia?
Yes, it was Phoenix Crematory.
And did she provide you with documents that correlated with Ms. McIver's cremation?
Yes, she did.
And any of the individuals that you spoke to, were they able to provide you with a subsequent or second will of Ms. Diane McIver?
They were not.
And through your review of all of the documents that you participated in the seizure of throughout the search warrants, go through the hard drive of Diane McIver computer.
Yes.
And where was that computer located prior to the district attorney's receipt of it?
It was at U.S. Enterprises, the Corey Group.
And did you go through, was that sent to the GBI?
It was.
And was it examined or imaged by Ms. Lisa Arnold?
Yes, it was.
And did you receive the imaging of the hard drive from Ms. Lisa Arnold?
Yes.
And did you go through each and every document from Mrs. McIver's hard drive?
Yes, with much needed help, but yes.
And from Mrs. McIver's hard drive, were you able to obtain or did you find any documents related to her financial standing?
Yes.
Again, that would be called for a hearsay response. Have to look at the documents, make a determination about what they are, and then
Right now, I'm just working through, we also have some business records, but those would have come through a different source than the hard drive, so I agree.
And with all due respect to the defense counsel, I believe the hard drive was admitted into evidence through a stipulation about what the procedures that Ms. Lisa Arnold took.
yes, but that does not answer your question. Yeah, it was just authenticated.
I mean, there may be items on there that you want to use if the right foundation has been. I'm not disagreeing with your representation of what happened through the Lisa Arnold stipulation and evidence being admitted. That may be exactly right. But I guess you'd need to, that there may be some things on there that you want to use. I don't know.
Right. Were there items on the hard drive that dealt with numbers?
Yes.
Numbers? Is that the question?
That's the question, that dealt with numbers.
And how did you
Same objection I reckon, whether it's letters or numbers,
Symbols?
simple.
Did you also, from the examination of Mrs. McIver's computer, look into her emails?
Yes.
And were there a lot of emails?
A lot.
And the vehicle that you said was stored in the district attorney's facility, is that vehicle available for the jury's view?
Yes, it is.
No further questions at this time, right?
Mr. Harvey, do you have any questions for Ms. Investigator Griffin?
Before Mr. Harvey does, I can ask one additional question.
You may, because he was thinking. He's thinking. We'll give him a little more time. The end is near for direct examination, so be near.
I know, I'm still thinking.
Okay.
I'm a slow thinker.
And Ms. Griffin, through your employment with the district attorney's office, do you interact with the district attorney, Mr. Paul Howard?
Yes.
And what kind of phone does Mr. Howard use or have? Cell phone?
He has an iPhone 6.
And how long has he had that iPhone?
Maybe about,
Based on your personal observations
Keep going.
before defense counsel objects.
yes, about 2 years, maybe, almost 2 years.
No further questions.
All right. Mr. Harvey, do you have any questions for Investigator Griffin?
Yes.
Okay.
Good morning, Ms. Griffin. How are you?
Good morning, Mr. Harvey.
I'm smiling. You're smiling. Good. I understand that you came on board in this investigation at the end of March in 2017, correct?
Yes, sir.
At the time that you had come on board, a couple of things had, in fact, been done in the investigation, correct?
That's correct.
The vehicle that you have described to us had been processed by the APD crime scene unit, correct?
Correct.
So if there is a crime scene and the vehicle itself is that crime scene, then that had already been photographed, processed, measured, so whatever measurements were taken in September of 2016, correct?
Correct.
Then the vehicle had been released, correct?
That's correct.
It had been released back to Mr. McIver.
Yes.
Subsequently, the Fulton County District Attorney's Office got a court order to keep the vehicle, correct?
Correct.
And that vehicle was returned in October of 2016, correct?
I'm not sure if I'm following you.
You know ADA Mike Sprinkle, correct?
Yes, I do.
All right, and you know that the expedition was returned on October 7th of 2016 when James Hughes returned it, correct?
I'm familiar.
And Mr. Sprinkle got a court order.
I mean, with your question, can you
Okay.
ask it again?
All right. You understand that on October 7th, Mr. James Hugh returned the expedition to the Fulton County District Attorney's Office.
Okay, I'm with you now.
Okay.
Yes.
And that in October of 2016, ADA Mike Sprinkle, who we've seen on the witness stand, got an order, a court order to hold the vehicle. So that was done back in October of 2016, right?
Okay, yes.
Okay. So one thing that was done, the vehicle was processed, the vehicle was seized, you had the vehicle as of October of 2016, correct?
That's what I'm unsure about. I know in February the 2017 date is when we received it back to hold, to keep.
Okay. Well, then James Hughes turned it into whom? On October 7th of 2016, because that's what Aaron Smith testified to.
I would have to look at what you're speaking of.
Speculation as well as your set.
Okay, so you don't know whether or not it was turned in on October 7th of 2016. correct?
Not to us, the Fulton County DA's
You
office.
don't know whether that was done on October 7th of 2016?
No.
Okay. And you don't know whether or not the Fulton County District Attorney's Office got a court order on October 28th of 2016 to keep the vehicle?
I can't recall that right now.
Okay, you just don't know. That's the vehicle. You also know that the weapon that was involved was seized immediately in September of 2016, correct?
Yes, I did see that.
And that weapon was sent to the crime lab, correct?
Yes, it was.
In 2016,
Yes.
correct? And it was examined in 2016, correct?
Yes, it was.
Okay. So the crime scene, being the vehicle, had been processed, turned over. The weapon had been processed and turned over. The documents at Corey, you're familiar with the documents that were taken from Corey, correct?
Some of them, yes.
Yes. Some of them?
Right. I mean, at what date are you referring to specifically?
They were gathered by people at Corey, correct? They were taken out of a locked file cabinet, correct?
Okay, yes, I'm familiar with that.
And they were gathered by the people at Corey who went through those documents, put them in boxes for pickup, correct?
Yes, that's correct.
So all the documents at Corey had been gathered by Corey personnel.
I'm going to object, same objection that the defense counsel had when I went correct. This is all calls for hearsay.
Okay.
Well, if we're talking about course of conduct, which you allowed over my objection, then I am entitled to go into what was testified to on direct examination.
You are, without getting into hearsay areas.
Okay. Did you gather those documents and review those documents? The documents that came from the file cabinet at Corey?
To my understanding, those documents were given to the defendant.
Okay, and were they retrieved?
I have not seen those unless those were some of the ones that was in the search warrant that I conducted on April.
In the condo?
In the condo, yes.
Okay.
But I wouldn't know if those were the same documents that were given him because that was before me.
And you also got the state,
Yes.
I mean you, got some documents from the people at Corey prior to your entry into the case. Those documents you reviewed as well, correct?
I'm familiar.
Okay. One of the documents that was produced from Corey was a 2006 will, correct?
Okay, yes,
Okay.
correct.
And that's the will that was offered for probate, correct?
Correct.
All right. Processed the car, investigated the gun. A 2006 will was offered for probate, correct?
Correct.
And through 4 search warrants, review of any documents provided to the state, it is my understanding that throughout all this investigation, there has never been recovered a second will, correct?
That's correct. Only testimony.
Okay. I think that's all I have. Thank you.
Mr. Abate, any redirect?
Yes, Mr. Very briefly. Mr. Harvey on cross asked me about the gun and his recovery process.
He did.
And have you had an opportunity to look at old that gun?
Yes, I have.
And did you do any investigation about the firearm that was located inside the SUV?
I don't know what that question means. Any investigation, I think it's pretty broad.
If there's a document you want to share with Mr. Harvey.
While Mr. Harvey looks at that, I'll ask you some questions. Do firearms have serial numbers?
They do?
And can those serial numbers be traced?
Yes, they can.
And did you trace the serial numbers on the firearm that was located in the vehicle?
Yes, I did.
And did you have an opportunity to watch the interview that was done with the defendant at APD?
Yes, I
Do
did.
you recall where the defendant said he got the firearm that was used to shoot Mrs. McIver?
And how does this read? All right.
Why
I
did he
didn't
know?
ask about the provenance of the weapon. I said the weapon was recovered and it was processed by the crime lab.
And I would say that this is also part of the processing of the firearm that was located in the vehicle.
Okay, I think what happened with the firearm was explored by both sides. You can continue to explore it.
And do you remember watching that interview?
I do.
And do you remember where Mr. McIver said that he got or
But
purchased?
not in this context. Not with commentary about what may or may not have been said by someone in another interview.
I think if you want to work through the document in your hand, you can do that. The dot you're trying to connect now would be appropriate in a different setting, like the closing argument.
And my only response to the defense counsel would be, during his cross-examination, he asked about all the things that she reviewed that APD as well as her predecessor had done. So this is part of her review of, you know,
But the interview says what it says, so I think the objection I think I'm sustaining is a question that says, do you remember where in the interview X was said? That, I don't think that ties in so much with the cross, but what you have in your hand, if it's what I think it is, you can continue to explore.
and I'm going to show you what the market states is 510 Investigative Griffin. Do you recognize that document?
Yes, I do.
And what is stated in 510?
It is a firearms trace from the ATF, alcohol, tobacco, and firearms unit, and they trace the weapon.
Yeah, but then about the content. Not
And
the content, what it is,
Right.
not the content.
Don't go, it's just, she said what it was, it's a trace on the weapon, period.
And does that document, the trace, the ATF trace on the weapon, appear to be a fair and accurate copy of the trace that you received after you ran the serial numbers for Mr. McIver's weapon?
Yes.
At this time, Your Honor, the state would tender what the market states of 510 in evidence.
No, I've got an objection to the document because it hasn't been authenticated in any shape, form, or fashion, other than it's something she received from somewhere. So I do have an objection to the document.
Okay.
A foundation hasn't been laid, nor has it been authenticated.
I can definitely ask additional questions to lay the foundation from which Investigator Griffin says she received a document from ATF.
You can ask a few more questions. Tell me the authentication.
Well, it's, first place, it's classic 801. And unless it is properly authenticated under perhaps some other 8 series exception, then it is not admissible because it's 801. Yeah.
No, I understand what you're saying. I'm just trying to work through a vehicle. Someone had a vehicle registration, something where it's the product of a database, et cetera. But this is in connection with an investigation that it was prepared, so it's not. I guess you can ask some more questions, and we'll see where you get with it.
Okay. Now, Investigator Griffin, can you explain to the jury what you do with the serial number from the weapon? Who do you send it to?
Yes, you submit a request to the ATF, which is the Alcohol, Tobacco, and Firearms unit, with the pertinent information from the weapon that you're researching, and then they give you results back.
And why do you send that request to ATF? What do they do?
Yes, they traced the actual weapon to see.
And again, I don't know whether this witness knows what the ATF does.
What is ATF, or what is the ATF?
She said several times, alcohol, tobacco, firearms.
What I thought too. But
Okay.
what does that agency do?
Yes, they,
I'm sorry, but this witness hasn't been qualified to testify about what the ATF does, how they do it. Whatever they may do is something out of court, offered for the truth of the matter asserted.
Okay, I agree.
Have you ever run an ATF search before?
yes,
How many times?
numerous.
Did you run ATF searches while working at the Fulton County Police Department?
Yes, I did.
Have you run ATF searches through your 10 years here at the Fulton County District Attorney's Office?
Yes, I have.
How many would you say?
Maybe about 20.
And when you have done those searches, did you receive a document similar to the one you are holding, State's Exhibit 510?
Yes,
Did you follow that same procedure when you ran the serial numbers for the weapon located inside the King Ranch expedition?
yes, I did.
And is State's Exhibit 510 a fair and accurate copy of the document you received from ATF after providing them with the serial numbers from the weapon that was found in the expedition?
Yes.
Same objection.
So here's where we are. You have, I think, Mr. Abate, done a great job of having the witness describe that effectively there's this box that spits out these reports and you put in a serial number. You are seeking to offer what's on that report as the truth of the matter asserted there. This gun belongs to X, according to not this person, but whoever is hiding inside that box generating the reports. I think absent some other certification or testimony, the hearsay objection remains a valid one. I don't know that what we're getting at is hugely in controversy, but that doesn't make the objection less valid.
Yes.
So you may want to explore this with a different witness at a different time, but I think you've hit a dead end with this witness.
Yes, Judge, and we can call an additional witness.
Any other questions for Investigator Griffin?
One last question, Investigator Griffin. What kind of information are you requesting when you make a request with the agency, ATF?
Ownership and registration information to that particular weapon.
I'm sorry, I missed that.
Can you just repeat that right into the microphone?
Ownership and registration information to that particular weapon.
Nothing further.
I have one question to follow up on that.
Okay.
If the information on the ATF report might include the purchaser, correct?
That's correct as well.
As opposed to any current owner, because any current owner or person who might have possession of that gun could have been legally transferred from the purchaser, correct?
Correct.
Thank you.
Jurors, if you have any questions for Investigator Griffin, if you would pass them to your left and down, Deputy Murphy will collect those. We'll see where we go. I think after that, we'll take our morning break. Thank you. Left off. Investigator Griffin.
Yes, sir.
Thank you. Do you know why the SUV was returned to Mr. McIver or someone by the district attorney's office once and then reclaimed again? And if you, question is, do you know? Let me ask that better. Why was it returned the first time?
I know that there were additional testings that we wanted to perform on the actual vehicle with different experts.
Any follow-up based on that?
Who returned the vehicle the first time, if you know?
I do know that Detective Darren Smith with the Atlanta Police Department.
You returned it to the DA's office.
I'm sorry?
You returned it to the DA's office?
He returned it back to the defendant.
And who gave it to the DA's office?
Yes, it was through James Hugh and Detective Darren Smith, and that's how we obtained the vehicle again.
And you talked about additional testing. Was the reason that additional testing needed to be done was because it wasn't done in the initial processing by the Atlanta Police Department? The testing that you talked about, had that been done by the Atlanta Police Department?
That had not been done.
Mr. Harvey, any follow-up?
Sure. I'm sorry, but the testing that you had done by Mr. Knox and Mr. Rohn that you told us about, that wasn't until October of 2017, is that correct?
That's correct, and it was held in February 2017.
The order was signed in October of 2016 and it was returned in 2016, but the testing that you're talking about didn't occur until October of 2017, is that correct?
That's correct.
Okay. And that was by people that were paid by the district attorney's office, correct?
Well, they were employed as experts, so yes.
Yeah, okay, well, did they were paid, right?
Yes.
Okay. And Mr. Knox got how much?
I don't know.
Okay, how about Mr. Rohn?
I don't know.
That's all, thank you.
All right. Thank you, Investigator Griffin.
Thank you, sir.
You can step down. Ladies and gentlemen, we're going to take our morning break. Lunch break is going to be just before 12:30 for your planning purposes. You recall the routine, and if you don't, I'll remind you. During the breaks, whether it's for lunch or whatnot, you guys are free to chat, do what you want. Just don't talk about the case, no outside research, anything like that. We'll get you back in here in about 10 minutes. I know there's at least one matter that we need to take up outside your presence, so the break may run a little bit longer, but it wasn't something we could do before we pulled you in here this morning. All right. Thank you, Deputy Murphy.
All rise for the jurors. Please be seated.
Who's your next witness going to be? Okay, then why don't we take the break first, and then when we get everyone back here in 5 or 6 minutes, at least the folks who need to be back here, we'll get Dr. Sellers on the stand outside the presence of the jury to cover what we need to cover, and then assuming he's going to be permitted to testify, boom, the jurors can come on in with Dr. Sellers here. If the finding is otherwise, then whoever is after Dr. Sellers, we can bring on in.
All right, and I'm also going to approach with the signed stipulation only because I'm going to ask you to publish that probably sometime soon.
Oh, okay. We had a couple of sidebars that related to Carl Rohn. Mr. Harvey had a couple concerns because Mr. Rohn hadn't been called to testify, and Mr. Harvey was under the impression Mr. Rohn would not be called to testify. And there were some references to steps Mr. Rohn took that weren't reflected in the video that Mr. Harvey had. Mr. Abate assured Mr. Harvey that there was additional information from Roan or from the DA's office about what Roan did, in particular cutting into a seat that had been provided to the defense. We didn't really need to resolve that because my understanding of the discussion with the attorneys is that there wasn't going to be more with Mr. Roan than what we heard, and people went back to their tables content enough with that. Mr. Harvey, anything more you want to get on the record concerning the two Roan sidebars?
No, sir, thank you.
Mr. Abate?
No, Your Honor.
Okay. Anything from the defense before we break?
No, sir.
Then we need Mr. McIver and whatever attorney is going to be wanting to ask Dr. Sellers questions about what he knows about the case and how he learned about it in about 5 or 6 minutes. Thanks. Does that give you enough time? We'll have a full-blown lunch break.
No problem.
About 12:30. We're going to go back on the record in State versus McIver. Deputy Murphy, if you would please swear in Dr. Sellers. Dr. Sellers, good morning. I need you to stand back up so you can
All is subject to recording and monitoring.
If you will, raise your right hand.
Information collected and used by corrections.
There's something weird going on with the PA. It's going on in chambers as well.
Okay.
So,
Raise your right hand. Do you swear and affirm that the testimony you should give the court today
Are you doing, Ted?
is the truth, the whole truth, and nothing but the truth, so help you God?
yes.
Yes, if you will, please have a seat. Get as close to the mic as possible during your testimony. For the purposes of the court's record, please state and spell your name.
Marty Sellers, Martysellers.
All right, before we get started, has that been stopped?
It has.
Thank
I
you.
had to mute the system too, but I also paused the actual playing.
Great. All right. So, is this your witness, Ms. Conver? All right. So don't sit down. And again, the limited purpose for having Dr. Sellers in here outside the presence of the jury, as I'm recalling, is to establish Dr. Sellers' familiarity with this matter and the basis of that familiarity.
Sure.
Okay.
Good morning, Dr. Sellers.
Good morning.
If you would, just kind of introduce yourself to the court and tell them what you do, just generally, so he has an idea of who you are.
All right. Again, my name is Marty Sellers. I am a surgeon at Emory University specializing in transplant, but I was on general surgery call the night in question. So I'm a surgeon at Emory.
Okay, on September the 25th of 2016, at some point do you receive a call that brings you to Emory to operate as a result of being in on-call status?
Yes.
And are you actually one of the physicians who operate on Diane McIver?
Yes.
After that operation, once you complete sort of your involvement that evening at the hospital with her surgery and attempts to save her life, do you leave the hospital?
Eventually, yes.
Okay, after is sort of your primary involvement there that night, the surgery and the attempts to save her life?
That's correct.
Once you leave, do you have any other involvement in Mr. McIver's treatment or anything else there at the hospital that night?
Well, after surgery is completed, the responsibility is on us to inform the family of the outcome of the surgery.
And once you're done with that part of your responsibilities, does that complete your medical involvement there at the hospital that night?
It does.
That early morning. Do you tell the court, just so we can all get an idea of once this happens on September 26th, 2016, do you continue to stay involved in any way in the investigation or anything going on with the case?
No.
Do you follow the case in the media?
Peripherally, by when people come to me in the hall and say, did you hear this or did you see this? And so actively, no.
Okay. Any conversations about the case while it's pending as far as detailed content about what people said or what people heard at the hospital the night that this happened?
No.
Once the case began, were you actually following the case before it began, before the trial itself began?
No.
And once it began, tell the court how it is that this sort of got back on your radar.
Well, I was about to go to bed one night, and my wife said, the jury selection for that trial is about to start or is ongoing. And I said, okay, thank you, and thought, well, based on some conversations that I had heard from other people at the hospital, I thought I would be contacted. I was basically asked by several people, have you been contacted yet? And I just kept saying no because I had not. And so I was a little bit surprised that the trial was going on, but again, it didn't really register to me that,
Did you say that you thought it was kind of unusual that you hadn't been contacted yet?
I guess just based on the fact that I was the attending surgeon and other people in the hospital had said they had been subpoenaed, I was, again, I wasn't, I guess, surprised, but I don't know what to say, but I was a little bit surprised that my wife said that the jury selection was ongoing, and I thought, well, I haven't heard anything, so I thought that might be a good thing.
Okay. And at some point after your wife told you that jury selection began, do you then reach out to David Ladner?
I did.
Tell the court who that is.
Honestly, I think he's not an Emory attorney, but he was the outside counsel that was retained just for witness preparation, I would guess. I don't know, honestly don't know his official involvement.
Okay, but coordinating with some of the doctors and staff, as far as you know.
Correct.
As it relates to contact with the DA's office.
Yes.
Okay. And did you ever contact, you yourself call anybody from the DA's office directly?
No.
And at some point, do you then receive a call from Mr. Rucker and myself, other attorneys in the office?
Yes.
At any point after this initial sort of flag from your wife that the jury selection is ongoing, do you actually tune into the trial, watch the live stream, anything like that?
No.
At any point, did you follow media coverage while the trial was ongoing?
No, I didn't follow anything. I had seen, someone had sent me an article that had AJC, that was in the AJC, so I got on the AJC website, and the lead article on the front, or the home page, was this trial, and it was the day that there were guns in the courtroom. I just remember seeing a picture of the guns, but other than that, I haven't kept up with it.
Okay, did you actually read the article itself?
No.
And as outside of that article and your wife sort of drawing your attention to the jury selection, does that sort of summarize your media contact as far as since this trial has been ongoing?
It does.
And have you talked to any of the witnesses from Emory Hospital or anywhere else who have testified as to the specific detailed content of their testimony?
No, other than getting a text from Dr. Hardy saying that she was coming to testify and wanted to know if I was coming to testify.
Is what you just told the court sort of the same outline of the involvement that you gave to me as well?
Yes.
Did he tell Ms. Convery the same thing recently that he just told us about his connection to the case? He said, yes, I told you the same thing that everyone just heard here. We'll see.
And Dr. Sellers, anything about any of the media coverage that you've experienced in any way, whether it's seeing a picture, glancing at an article, or hearing something from your wife or any other employees that affects in any way your recollection of the events that occurred on the 25th and 26th of September 2016?
No. No.
The information that you provided to us and that's been transcribed and since had an opportunity to review, is that information and the testimony that you anticipate potentially giving to this jury things that are based on your personal experience and recollection of what took place in the hospital that evening?
Yes.
I don't have any other questions, Your Honor.
Mr. Samuel, any questions for Dr. Sellers in connection with this area we're exploring?
I just want to clarify, you talked to no nurses or other than the text from Dr. Hardy, no other discussion with anybody who's been 20 different nurses and technicians and doctors and valets. You have an intern, or even Dr. Saeed, anybody since March 5th about this case?
March 5th, no.
All right. I'm comfortable ruling now, but if you want to have a discussion outside Dr. Sellers' presence, we can do that.
I don't need a discussion.
Okay. I'm going to allow Dr. Sellers to testify. You have preserved, I believe, your objection to some of the content of his testimony. You're welcome to renew it if he's asked about it, but that certainly is preserved. We had a pretty lengthy discussion before we took our break last Friday, 2 Fridays ago, about the concern you had when about Dr. Sellers' recollection about what Mr. McIver said. So,
well, there's only two things I would say. First off, I did confirm with the assistant DA, but I want to make sure the witness knows and the ADA knows that you posed some limits. And second, there was a motion to limit granted, I don't know, 6 or 7 years ago, it seems like, about doctors or nurses giving any opinions about demeanor, as opposed to, this is my observation.
sure.
And his transcript, you've got a copy I gave it to you Friday, is nothing wrong with it, but when he was interviewed by the DA staff and Ms. Griffin and all, it's just chock full of opinions. Again, nothing wrong with that.
Sure.
But I want to make sure that he knows he can't offer any opinions, even if the question seems like it may be eliciting it. I know that the ADA wouldn't be eliciting it because it would violate your granting or motion limiting as to medical professionals giving opinions about someone else's demeanor as opposed to simply observing what the demeanor is.
Sure. So those are well taken, both those reminders, one from many years ago, one more recent. So Dr. Sellers, it may well be that Ms. Convery or one of her colleagues talked to you about this. It's perfectly appropriate for either side to ask you, what did you see, what was going on, what were your observations? The distinction that we're making here is that you limit your testimony when asked that kind of question. What did you see the defendant do? I saw him do X, and not add to it, and boy, he sure seemed angry to me, or I was surprised he didn't seem upset, and I would expect someone to be upset in this situation. Now, if you are confronted with that question, were you surprised that he was not upset? Then everyone will have a chance to object, and if I overrule the objection, then you'd be able to answer it. But in particular, from the state, you'll get open-ended questions, and there are two constraints that I have imposed on the answers to open-ended questions to everyone who was testifying from the hospital. One for everyone, which was, please don't include your opinion as to whether someone seemed upset or not, or if it was odd to you, because that's not how you would expect someone to react. That everyone needed to stay away from. In addition, for you, I entered a ruling that said that the state ought not to elicit from you any physical description of your colleagues. Is it Syed? Is that the name? Dr. Syed. And so I'm confident that that won't be something Ms. Convery asks you. I want to be just as confident that that's not something that you would inadvertently say. Now, the caveat to that might be, and I don't control what either side does, but if you are then explicitly asked that by Mr. Samuel, there'll probably be a pause and everyone's eyes will get wide. But I will allow you to answer it if it is asked by the defense. But I want to be clear what I'm saying here. If you are asked an open-ended question by the defense, you need to stay away from those two areas. Don't offer an opinion as to whether it seemed someone's reaction seemed appropriate to you or anything like that. And also, please don't share with the jury any physical description of your colleague. If you are asked point blank, describe Dr. Syed, then we're all going to pause and say, are you sure you meant to ask that? I didn't mean to ask that. Then I will tell you, you may answer that question. Short of that extraordinary circumstance that I don't expect to arise, I need you to stay away from those two areas. Does that make sense?
Understood.
Any questions?
No.
Anything else, Mr. Samuel?
Thank you, Your Honor.
Okay. Are we ready for the jury?
Yes.
Let's bring them in. I think they're ready for us.
Judge, would you mind turning on the TV for me if you can go those adjectives?
Yep.
Thank you.
I'm not coming at you.
While we're waiting for the jurors to come in, I am going to request the court publish the stipulation prior to Dr. Sellers' testimony. Is it still in here and you want him to step out while you request?
It'll be right there. I need it though.
It's right there.
You still ready, Judge?
We are.
All rise for the jury.
It's not initial.
are present and accounted for, Judge.
Thank you. You all can be seated. Welcome back. This is Dr. Sellers. He's going to introduce himself to you guys in just a moment. You can take a seat, Dr. Sellers. He's already been sworn in outside your presence because we had to work through a few things. But before we hear from Dr. Sellers, we have another stipulation that I'm going to read into the record. The state and the defendant stipulate that Ms. Alicia Redding previously worked at the DeKalb Medical Center for 10 years and Northside Hospital for 7 years. In July of 2016, Ms. Alicia Redding began working for the emergency department at Emory University Healthcare. During the month of September 2016, Alicia Redding was employed as a nurse technician at the Clifton Road campus of Emory University Hospital. Some of her responsibilities at the time included patient care activities like drawing blood, inserting IVs and catheters, and setting fractures. When a patient enters the emergency department, they go through triage. Then they would see Alicia Redding or someone in her role, and then ultimately a doctor. On September 25, 2016, Ms. Redding was assigned as a nurse technician covering rooms 11 through 19 in the emergency department. Upon hearing about a gunshot patient in the emergency room, Ms. Redding went to the trauma room to attempt to assist in any way she could. Ms. Redding remembers being in the trauma room when Tex McIver first arrived and being there for approximately 25 minutes. She recalls that Terry Sullivan, Natalie Mosher, Nicole Smith, Allison Neely, and another tech were in the trauma room at the same time she responded. She does not remember seeing the defendant or Danny Joe Carter in the trauma room at any point. After Ms. Redding left the trauma room, she went back to rooms 11 through 19 and was standing in the area between rooms 11 through 14 near the family waiting room. Nurse Terry Sullivan approached Ms. Redding and explained that she heard the husband, the lady, and the lawyer talking. But since Ms. Sullivan cannot hear that well in one ear, Ms. Redding was asked to stand closer to see if she could hear what they were saying. Ms. Redding moved closer to the group of people Nurse Sullivan referenced and recalls the husband saying, "What am I going to do? What am I going to say?" Then Ms. Redding hears Mr. Maple say, "I'm going to prep you on this stuff." Ms. Redding hears the lawyer ask if they were arguing. The husband says that they were not arguing. Ms. Redding also hears the husband say, "In a shady area of town, holding gun in my lap." Ms. Redding does not see the female in the group say anything. Ms. Redding also recalls seeing the defendant and Danny Joe Carter on the phone at some point. Later, Ms. Alicia Redding approached a police officer, initially noticed by Nurse Sullivan, and gave the officer her name and phone number, and told him what she saw and heard. Ms. Redding later saw the defendant checking himself into triage and heard him say, "I need to check myself in. My wife just died." Ms. Redding is able to observe the defendant go to triage, and later she sees Ms. Carter, the defendant, and the lawyer leave the hospital together. I will make this a court's exhibit, and we can proceed. Ms. Convery, if you have questions for Dr. Sellers, who again has already been sworn in.
Am I supposed to introduce myself to the jury, or is that
You're going to follow directions from here on out.
I will.
Questions.
I will do my best.
All right.
Introduce yourself, Dr. Sellers, to the jurors again and tell them where you currently work.
My name is Marty Sellers. I am a surgeon at Emory University.
And how long have you been a surgeon for Emory University?
Since June of 2016.
Okay. Tell the jury a little bit about your background and training that allows you to do that job.
Specifically, I've finished training in general surgery and then did a transplant surgery fellowship. And as part of my responsibilities, at least at the time, was to included general surgery call.
And so you started with Emory University in June of 2016?
Correct.
Where were you working before Emory?
At the most recent had been the University of Pittsburgh.
And how long were you with the University of Pittsburgh?
Just for 7 months while I was waiting for the contract negotiations to be completed with Emory.
And prior to that?
Piedmont Hospital here in Atlanta since October of 2005.
Right. And while you're working for Piedmont, Pittsburgh, and Emory, were you a surgeon, same type of surgeon? Or did you have different fields of specialty?
Predominantly transplant and liver-related, non-transplant liver-related surgery.
Okay. And in your capacity with Emory in 2016, were you a transplant surgeon there?
No.
What were you?
General surgeon.
Okay. Tell the jurors, what does it mean to be a general surgeon at Emory in that capacity that you worked in?
In addition to general surgery, I did non-transplant related liver surgery. But the responsibilities include being on call for emergency room consults, inpatient consults, and seeing patients in clinic that have general surgery problems like hernias, gallbladder problems, things like that.
And then in your time at Emory, tell the jury a little bit about what it means to be on call, just what that means for your purposes when you're an on-call surgeon and you're actually on call.
Being on call means that any consult or patient that comes in to the emergency room or someone that's already admitted to the hospital, if their primary care team has a question that is a surgical issue, then I am the attending that covers that patient.
And what are the hours that you're on call at that time?
That was a weekend, so from Friday night at 5 o'clock until Monday morning at 6.
Anytime a call comes in, you're subject to having them.
Correct.
What part of, well, let me ask you this. Tell the jurors, what is the difference between a resident and an attending?
A resident is someone that is still in their training, being supervised by someone like myself who is an attending.
And in September of 2016, were you an attending?
Yes.
And when did you first become board certified in medicine?
Board certification in general surgery, September 9th, 1996.
And prior to working for Piedmont, were you still in the Atlanta area, or is it Piedmont Hospital that brought you down here to Atlanta?
I was at the University of Pennsylvania in Philadelphia, in Children's Hospital there, so Piedmont brought me to Atlanta.
Let's tell the jurors that September 25th, 2016, were you working as an on-call surgeon in the same capacity we've been talking about for Emory Hospital?
Yes.
And do you remember that particular weekend, whether or not it was a busy weekend for you?
I remember because of what happened Sunday night, I was going to bed and remember thinking, this has been a fairly light weekend. I had done one case the day before, and a person I think that had a perforated ulcer on Saturday morning, and other than that had probably a few consults, but did not have any surgery cases.
And sometime that night on Sunday evening, after you thought, oh, it's been quiet, did you get a call?
Within a couple of minutes, I got a phone call from Dr. Syed.
Okay, tell the jurors about what time that phone call came in.
It was 10:57.
And how is it that you remember that precise time, 10:57?
I'm strange in a lot of ways, and one of the things I can remember is numbers. So I do, and that's a phone call that sort of gets indelibly imprinted on your mind anyway. But I do specifically remember it was 22:57.
And you said you got the call from who?
From Dr. Syed.
And who is Dr. Syed?
He was the administrative chief resident at Emory, and meaning he was in his last year of training, and he had been called by Dr. Razavi, who I guess at the time was a second-year resident, about there being a gunshot wound in the emergency room.
And so the news about a gunshot wound makes its way to you. Do you have a particular reaction to learning that there's a gunshot wound at Emory?
My immediate reaction was, I have to go. I mean, I didn't really think, I didn't overthink it.
Had you responded to a gunshot wound or been involved in a gunshot surgery at Emory before?
Not at Emory, no. Other than, I'll just qualify that with, as a transplant surgeon, you do a lot of organ procurements, and some of those patients might have been gunshot victims. I'm not sure.
But as far as dealing with the real-time trauma of a gunshot wound,
That's the first.
so you got to get there as quick as possible, I would imagine. Tell the jurors, what part of town were you in or were you living in when you got the call?
In Sandy Springs, about 25, 30 minutes away.
And after receiving that call at 10:57, what is the next thing that you do?
Get up, get dressed, and get in the car to go.
And do you have an idea in your mind about how long it takes you to get from the Sandy Springs area to Emory Hospital?
That time on a Sunday night, traffic is light, I would guess 20 minutes.
At the time that you got the phone call from Dr. Saeed, did you, aside from learning that there was a gunshot wound, did you have an idea as to the status of the patient?
I had an idea because he had told me he had done the emergency room thoracotomy where he had opened the chest in the ER, and that in and of itself indicates a patient in extremis.
Why do you say that?
Because that's a last-ditch effort that people undertake in order to save someone's life in the emergency room once they lose consciousness or lose a pulse.
And I think you said, but just so the jury understands, what is you said a thoracotomy? What is that?
That's when you open the chest for any reason, but in this circumstance it was done to put a clamp on the main blood vessel leading out of the heart so that the blood pressure could stay high enough to perfuse the brain.
In the 20, 25 minutes it takes you, do you arrive at some point safely to Emory Hospital?
I do.
What do you do when you pull up there?
Our parking lot is far enough away to where I didn't want to take that time, so I drove into the valet area at the ER and gave them my keys and ran up to the operating room.
And do you go straight from valet area up into the OR itself?
Yes.
I'm going to show you some photographs that have been previously shown to defense counsel. It's going to be State's Exhibit 500 through 508 sequentially. Take a look at these ones. Do you recognize those?
Yes.
And how do you recognize those exhibits, or those pictures?
They are the entrance into the surgery waiting room and hence into the operating room, and the last two pictures were of the consult room where we spoke.
Okay. And our State's Exhibit 500 through 508, and all of those areas, a fair and accurate depiction of how those areas actually appear in the hospital itself.
Yes.
I'm going to tender 500 through 508.
No objection, they are all in there.
State's Exhibit 500. Tell the jurors what we're looking at in 500.
That is the elevator where patients and family will get off immediately in front of the surgery waiting room reception desk.
Okay. And are these the elevators that you take to get into the OR, or you take a different?
Oh no, I take the stairs, especially every time I take the stairs, but especially that night.
Okay. And is this the emergency room? I'm going to show you 502. Is this one level up from the emergency room entrance where you would have come in valet?
This is the surgery waiting area, and the operating rooms are on floor 3, and the ER is on floor 1.
I'm going to show you State's Exhibit. In State's Exhibit 502, is this sort of, we'll just tell the jury what we're looking at in 502.
This is the view that I would have seen coming straight out of the stairwell, and I would have gone into, I don't know how to point.
Just press on the
If
screen
you
as
touch
well.
the screen, it should register
Press
your
hard
finger,
enough.
but we were,
So I would immediately come out of, this would be exactly what I was looking at coming out of the stairwell, and I would be heading towards that door to go through to get to the dressing room to get changed into scrubs.
And State's Exhibit 503. What do we see in State's 503?
That is the entrance into the operating room. Beyond these two double doors here, you have to have cap, mask, etc.
Closer look at State's 504.
Closer view, yes.
Once you actually make your way, and are these the set of doors once you're kind of scrubbed up, ready to go in, this is how you actually enter in to the surgical area?
Once you have your scrubs on, yes, you'd actually, the scrub sink is beyond these doors.
And what can we see in State's 505?
This looks like the
This might help. 506.
close up, yes. This is the, these are the double doors that we were just talking about that are now open into the operating room area.
And in State's Exhibit 506, do you actually see the room where you operated?
Yes, 21.
So you told the jury that you make your way in and you go through the process to sort of get scrubbed up so you can go in. Once you actually make your way into the operating room, tell the jury what's going on in there.
Well, there's a bustle of activity. The patient is already asleep on the operating table. Dr. Syed had appropriately previously made the incision by the time I had gotten there. And there was just activity that you would expect in someone that was struggling to survive.
And so had the surgery itself and the actual attempt to save her life already began before you get into the operating room?
Of course, yes.
And why is it that he is able to do that, a resident is able to do that before an attending arrives?
Well, at his level of training, he would be expected to be able to do that. I mean, every chief resident in the country would be expected to do that. And Dr. Syed is especially talented, so it would be, I was not surprised at all that he had started when I got there.
About what time, best estimate, would you have come into the operating room to actually begin your involvement in the surgery itself?
I would guess by the time everything transpired for me to get into the operating room would have been 11:30.
Once inside the operating room and you're involved enough and caught up to speed, are you able to tell the jurors about what was some of the damage that you noticed right away as a result of the gunshot wound?
Just a lot of blood everywhere, including on surgical pads or gauzes that had been placed in to evacuate some of the blood. And then the patient's open with the midline incision made.
I'm going to show you what's been marked and shown to the defense counsel. The State's Exhibit 511 and 512. Do you recognize both of those?
Yes.
And our State's Exhibit 511 and 512, fair and accurate depictions of the anatomy, sort of an inside look at the front and back of an individual.
This is a generally good picture of normal anatomy, yes.
Okay. And would using 511 and 512 assist you in your testimony as to what specifically you saw inside the body that night?
Yes.
I'm going to request permission to tender and then publish State's Exhibit 511 and 512 demonstrative evidence.
Any objection, Mr. Samuel, to the state using 511 and 512 for demonstrative purposes? No. Okay. They are admitted for those purposes.
Dr. Sellers, if you could, look on the screen in front of you, and let's kind of orient the jury, tell them what we can see here in State's Exhibit 511.
This is an anterior view, meaning you're looking at someone's front side with the skin of the chest wall and the abdominal wall taken away. So you're looking at the internal organs of the chest and the abdomen.
And State's Exhibit 512.
This is the posterior view, or a view from the person's back.
And what can you see sort of in the middle here and then up and down? What is that?
That is the spinal cord.
And what are the sort of notches that we see right off the spinal cord?
These are,
You said to press real hard. And, yeah.
so these are part of the spine or this vertebral column that had been taken away in order to give you the view of the spinal cord. These spaces here are the spaces between the ribs. The white things you see are the ribs.
And what are the little notches on the spine itself called?
Spinous processes.
Okay, and the spinous processes, what are those made of?
Bone.
And are they of a hard enough substance to, do they share the same characteristics as the rest of the bones in your body?
Yes.
As you come into the operating room on the, still 25th, going into the morning of the 26th, did you know or have any information about where the wound was, the entrance wound?
No.
Were you able to, at your initial part of the surgery, see the exit wound?
No.
At some point in the surgery, did you learn that there was an exit wound on her front side?
Yes, when we finished, we looked at again, the incision had been made by the time I got there, so that part was not visible to me until we closed.
Okay. And so is State's Exhibit 511 consistent with the view that you really had when you came into the operating room?
Generally speaking, yes.
And tell the jurors what, you told them you noticed a lot of blood and damage as a result of the gunshot. What did you do to try to stop that bleeding?
Well, what Dr. Syed had done in the emergency room effectively stopped the bleeding because it kept any blood from going past the point of his clamp downstream from that clamp, and the area that was injured was downstream from that clamp.
And where was the clamp itself placed?
It was inside the chest cavity, which is why he opened the chest in order to be able to place that clamp.
And where did he place it?
On the distal aorta just above the diaphragm.
What is, so the jurors can understand, what is the distal aorta? Why is that such an important place to clamp or stop the bleeding?
Well, it's the most accessible. What you want to do with that maneuver is preserve blood flow to the brain and the heart, because those are the two that are least tolerant of not getting blood flow. The abdominal organs can withstand some ischemia or some lack of blood flow for a lot longer period of time than the brain can. The brain is, anywhere from 2 to 5 minutes, certainly no more than 5 minutes, is irreversibly dead without blood flow. So the clamp is put on at that point in order to preserve blood flow to the brain. So the location of that clamp just needs to be downstream from the blood vessels that take off to go to the brain, and that is downstream from those blood vessels.
And do you see on State's Exhibit 511 the area where that clamp would have been placed?
It's not visible from here because you would have to, if you took all of these organs away, the aorta would be coming down in the back here. His clamp would have been, here's the diaphragm, his clamp would have been here above the diaphragm.
If you can, show the jurors, and if you need to, if it's easier, we can step down and show them, but where is the diaphragm on that picture, and what is that?
I'm having a hard time putting my finger where I want, so.
You can grab the pointer in front of you and stand up very carefully, don't fall off that ledge there, and sort of point to them where the diaphragm is.
Yeah, thank you. So the diaphragm is this white line goes from left side to right side. This is the patient's right side. So this is the right dome with the right cruise of the diaphragm, or I'm sorry, right dome with the diaphragm here. This is the left diaphragm here.
And how far is the diaphragm, the top sort of edge that we see there from, or how far would it be from a patient's heart?
The heart is immediately on top of the diaphragm.
And can we see that there, State's Exhibit 511, the heart?
It is this space right here.
Okay, thank you very much. And if I ask you something that requires, it's easier to use the pointer, just go ahead and feel free to do that. Just make sure you keep your voice up for me.
Okay, my experiment, I think it's easier to do it here.
It's nerve-wracking. I don't want you to fall on.
We've tried that.
Okay, and so when you told the jurors about the clamp, once you are actually able to do that, is the next step then to sort of repair the areas that are damaged, that are still bleeding?
Well, yeah, the first step is to make sure that there's not an injury to the big blood vessels in the back. And Dr. Syed had done the maneuver that sufficiently allowed us to say, yeah, no major injuries to the aorta or the IVC.
What's the IVC?
And that's the big blood vessel that takes blood from below the diaphragm back up into the heart.
So where was the primary source of damage, and how is it that you saw it there?
Well, we were able to see, I mean, it's obvious where at least the general area of injury is, or was, and once we had confirmed that injury to the blood vessels in the back was not an issue, we then explored the area where the injury clearly had, where the bullet track clearly had come, and were able to see that it had transected the blood vessels going to the spleen.
Okay, when you say transected the blood vessels, what do you mean?
Had cut them into, yeah.
And the image that we see here on 511, were you able to see the damage just from looking here, or did you have to do some maneuvering?
Well, in order to prove that the damage, that there had been no injury to the blood vessels in the back, Dr. Syed had detached the intestines here and sort of folded them over. And that was not an issue. So the area that we were targeting was because of the source of clear injury, which was in this area in the abdomen.
And the area that you just indicated on 511, is that, do you see the vessels really that would have been affected by the gunshot?
The vessels are not visible in these pictures, no.
Okay. Are they on the organ themselves or behind?
They would, and I swear I touched one spot and it lights up somewhere else. You can see a dotted, and this actually might be easier to stand. You can see a dotted line here. This is the pancreas. Here, that should say pancreas. The dotted line of the pancreas outlines its body. Thank you. And it's dotted here because it's behind the stomach, so you can't see the entire pancreas.
Okay,
But-
so fair to say if we remove the stomach that we see sort of laying there in front, you can see the whole organ itself. The spleen would actually be larger than the little yellow part we can see there on 511.
Right, the spleen is over here at the tail of the pancreas. This is the tail. The pancreas is here. The blood vessels come out of the aorta, from the aorta, straight out this way. And the blood vessels to the spleen, the artery goes on top of the pancreas to the spleen. The vein comes out of the spleen back towards the liver, right adjacent to the artery, right on top of the pancreas.
Okay. And so damage to those vessels, fair to say that caused a significant amount of bleeding.
Yes.
Tell the jurors why damage to that area of vessels in the body can be, and in this case was life-ending.
Well, part of the issue is in addition to the vessels being major blood vessels, the cavity into the abdomen, or the lining that gave them access or blood access to the lining of the intestine or the lining of the abdominal cavity, had been penetrated by the bullet too. So blood had access to a big open abdominal cavity that wasn't able to keep it contained.
How far was the injury that we're looking at here, that you just sort of showed us the general area? How far is that injury from Ms. McIver's heart?
It would be just a few centimeters, a couple of inches.
And if the bullet, let's try States is either 512 again. The exit wound that I asked you about before, that you are able to eventually see after surgery, about where did that exit wound fall on the body on the front side? I'll show you 511 again, and I can see it.
It would be immediately in front of, again, I'm going to target this knowing where it would be in this area here.
And were you able to look at or examine the entrance wounds, or where the bullet came into the body at all?
No.
Did you notice any part of your treatment involve you analyzing or looking at that wound in any way?
From the outside, no. From the inside, we had spicules of bone that we noticed in the bullet tract, and in exploring that, we were able to confirm that it had injured at least one of the vertebrae. I couldn't tell which bone in the back, which spinal bone it was, whether it was 11, 12, etc. But it was clear that the bullet had gone through the bone.
And what is it about what you observed that lets you know that a bullet actually did come into contact with some part of the vertebrae?
Because there were spicules of bone throughout the tract and around the vertebra.
Is the substance there on the actual spine itself and the notches that we talked about before, is that of a substance that's hard enough to potentially deflect the actual wound tract itself? Change
Yes.
the trajectory should it hit one of those bones?
Of course, yes.
How long, Dr. Sellers, were you in the OR with Dr. Saeed trying to save Diane McIver's life?
I would expect I was there. I remember thinking about this. We were there probably an hour, maybe a little bit longer.
And at what point is it that you decide that the surgery is not going to be successful, or that your attempts are not working?
After that period of time, but up until that time, we had tried several. One of the things that we had done had been to remove the clamp from the chest, and which was really not very accessible to us, as down in the abdomen. But the aorta comes through the diaphragm, obviously, and put up the other. And so if here's the diaphragm, I'm getting better. The clamp put on in the emergency department would be up here above the diaphragm. We're operating down here through a long midline incision here. In order for us to more readily take the clamp off, put it back on, we needed to access the aorta below the diaphragm, which that was actually the first thing that I did once that I got into the operating room, because Dr. Syed had already done the other that we described. But once you have stopped the bleeding, we were able to see where the bleeding was. We put clips on the blood vessels that had been transected or that had been cut, so there was no ongoing blood loss. But since having a clamp on your aorta is keeping the blood flow from your abdominal organs, you have to restore that as soon as you can, as soon as you safely can, which with the blood vessels then control clips on them, it was safe to take this clamp off. So we put the clamp down below, our clamp, took this one off. The reason we did that was so we could have more readily access to that clamp to take it off, put it back on depending on what our blood pressure did. When we were when we were satisfied that all the sources of bleeding were controlled, we didn't want to unclamp the aorta and then have more bleeding, but we put the clamp down in the abdomen so that we could take it off and see what would happen to her blood pressure, because she needed perfusion, she needed blood flow to those organs that were below the clamp or downstream from the clamp. Every time we tried that, her blood pressure would fall so low, so fast that it was not survivable. After multiple attempts of doing that, and again assuring that all the sources of blood loss had been controlled, which included taking out her kidney, which had been injured, taking out part of her stomach, taking out the pancreas and the spleen, despite proving that there was no ongoing source of blood loss. Every time we would take the clamp off, in very short order, her blood pressure would get so low that it was not survivable. After multiple attempts of this, and after we had sort of lost our confidence that any of the abdominal organs below were survivable at this point, we decided to call off the efforts.
And you told the jury during your kind of explanation of some of the complications going on in the abdominal cavity that there were other actual injuries to the organs you just listed.
Correct.
And which organs were damaged as a result? And are these damages from blood loss or damages from the actual trauma of the gunshot itself?
The ones I alluded to were direct damage from the bullet.
Okay. And which organs were those that were damaged from the bullet itself?
The upper part of the left kidney, which is not visible here, but would be, it'd be in this area right here. Again. And the adrenal gland, which is part of that. The pancreas was obviously damaged because it was in the path of the bullet as well. The upper part of the kidney is immediately adjacent to the pancreas. The stomach had been traversed. The spleen, I don't think was injured, but we had taken the blood supply to it, and it was in the way in order to try to, to expose other areas. So it came out as well.
We've talked a lot with the jury about blood loss and some of the issues with it. You talked about her blood pressure being low. In a normal human female, about how much blood is contained in the human body?
The normal person is, we'll just say 70 kilograms, and it's about 70 cc's per kilogram, so it's about 5 liters of blood in a normal person. She was a little bit smaller than 70 kilos, so maybe a little bit less.
And do you have an opinion about this gunshot wound, about how much blood or what kind of blood loss we're talking about quantity-wise from what you saw there?
Well, when I got into the operating room, the amount of blood in the abdomen would be what you would expect, would be basically someone's entire blood loss or entire blood volume. Keeping in mind, she would have gotten some transfusions prior to that, so, but there was an extensive amount of blood.
Dr. Sellers, as a result of your experience in surgery, but with this specific surgery, do you have an opinion about the factor of time and why that's important, about how much time someone can continue to function with an injury like the one that you saw here?
Well, I didn't document how many times, but I would guess 8 or 10 times we tried to take the clamp off the aorta. And, you know, in that circumstance, you give everyone every chance you can think of to, until it's just completely unreasonable to continue, which is where we got to. But the time that she had had no flow to her abdominal organs at that point would have been an hour and a half, if not more.
And upon sustaining a wound like this, right when the gunshot happens, would you expect a person, or is it consistent with what you know about this injury, that someone might lose consciousness relatively quickly?
Yes.
Why?
Because their immediate blood loss and just the physiologic shock of the injury and the pain. And again, the blood loss keeps you from being able to pump as much blood to your brain because there's not as much in your blood vessels, so your brain is getting deprived of blood flow, which is what keeps us all conscious.
After you and Dr. Saeed and the other individuals in the OR make the call that your efforts are no longer reasonable, at some point do you declare a time of death for Ms. McIver?
Yes.
When was that?
I was told it was 12:45. I did not remember that until someone told me that.
Okay. And did you have access and have you been able to review the medical records in this case as well?
Yes.
Okay. And is 12:45 consistent with sort of your mental timeline of when you would have arrived to the OR and your time there in the operating room?
Yes. As I said, I thought we worked an hour, maybe a little bit longer, and if I got there at 11:30, and that 12:45 would have been about right.
After the time of death, what's the next thing that you do?
Well, we closed the abdomen and the chest wound, since she had a chest wound as well, and then the next responsibility is to inform the family of the outcome.
And why is that your responsibility?
I don't know what to say other than why would it not be.
And who do you do, in your time as a surgeon at Piedmont and Emory, have you had the occasion to deliver that type of news or just generally results of the surgery to families before in your career?
In the setting of deaths in the operating room, very rare, fortunately. But the times that it has been in the setting of trauma, yes. So I've done it before.
Okay. Had you done it before at Emory?
No.
And the time that this surgery came about in your sort of timeline of employment, how long had you been with Emory Hospital?
Not quite, 3+ months, I guess. Not quite 4 months.
Okay. Who would you have delivered the news with? Would it have been you alone, or
Dr. Syed and myself would have both felt responsible to do that.
And what's the first sort of step you take to do that so that you can deliver that news?
Locate the family is obviously the first step, and so when we were finished, we said, that's basically what we always say is, where is the family? And that's true whether it's a successful surgery or what.
And what happened next?
We were told that Mr. McIver was downstairs and would...
For this particular statement, I'm not offering it for the truth. It's just kind of the next step of how it is that he makes it to the next step of his process. But I can shortcut it and get it directly there.
I object to it being hearsay. If it's not being offered for the truth, it doesn't need to be asked at all.
Okay. I don't know that that's always correct, but here I think we can get to where we're going without that piece of information.
I will.
So I'll sustain it.
Dr. Sellers, in your time from immediately reaching out, trying to contact the family member so that you can deliver this news, and your time where you actually come into contact with that family member, was there a delay of some kind?
There was a little, because one of the things that's relevant is almost always, even at that time of night, the family is waiting in the surgery waiting area. And there was no one in the surgery waiting area.
Eventually, did you come into contact with Mr. McIver?
Yes.
And was he alone?
No.
At the time that he came up to have a conversation with you and Dr. Saeed, did you know who the other person was with him?
Yes. The comments were he wanted to wait for his attorney to get there before he came up and speak with us.
And when he gets up...
That's hearsay, Your Honor. He's relating what someone else told him because...
Right, I couldn't tell exactly how it was going to play out, but it sounds like comments were, so you all should disregard, ladies and gentlemen, what Dr. Sellers just said. And I'm going to have you structure this a little bit more, just so you're able to get to where you're trying to go without us bumping into this.
Sure.
Okay.
Did you, at the time that you came into contact with Mr. McIver eventually, did you have an understanding of who the other person was with him?
I did.
And when Mr. McIver did come upstairs with who all came upstairs?
Mr. McIver and the security person that was escorting him and the other person up.
Okay. Where did you go next?
Into the consult room outside or adjacent to the surgery waiting area.
I'm going to show you State's Exhibit 507. What's in 507?
That is the sign outside the door, or next to the door leading into the consult room where we delivered the news.
All right, and just so the jury can be oriented to the layout there, where is this room or the door there in 507 in relation to sort of what you see when you get off the elevators there?
It would be immediately behind the elevators. The view from the front of the elevators before, if you were to go straight through the back of the elevator, would be that room.
And once you get off the elevators here and we're looking at what we see in 501, is there a waiting area up there as well?
From this view, the waiting area would be to your right and the back. The elevators are immediately right here to the left, and the consult room would be to the left of that.
So there's another, once you exit these elevators, another set of chairs, general waiting area, in addition to this room in 507.
Correct.
What about State's Exhibit 508?
That is the inside of the room.
State's 508. Once you came into this room, tell the jury what happens next.
Well, Dr. Syed and I were already in the room, and I was standing immediately next to the door, which would be right here. Dr. Syed was standing over here by this chair, and Mr. McIver and his companion came into the room with the security agent, or with, I'm sorry, the security guard, and the chaplain, I think, was with them, or she was already in the room. I don't recall that specifically. But Dr. Syed took the lead and said, you know, please, Mr. McIver, have a seat. And he was pointing to this chair here. And Mr. McIver, basically before the sentence was able to be finished, he said, "Don't tell me what to do, boy," which was not in a threatening way, but in an aggressive way, I would say.
And after hearing this comment, did you sort of take over, or what do you all do in response to that?
Well, it caught us, I guess, off guard a little bit, but you know, I guess at that time, in someone's you know, delivering this news, and not knowing what they already know, there's maybe a little bit of latitude you give someone in terms of how they act. So we convinced them to sit down and started delivering the news, and basically, without recalling the exact words that we would have used, said that despite all of our efforts, the injuries that she sustained were just impossible to recover from.
And as you're delivering this news, at some point, does the defendant, Mr. McIver, interrupt you?
He does, and there were a couple of notable things that sort of stuck out. One of which was he was sitting with his, you know, knees on his elbows, and looked up and said, "I'm really trying hard not to lose it," or "I'm really trying hard not to cry." I don't remember specifically. I think I don't, but maybe a distinction without a difference. But he looked up and he said that.
And you remember that?
Yes.
At any point during your conversation with Mr. McIver, start to finish, did you observe any tears?
No.
Did he make any other comments to you while you are attempting to deliver this news or communicate to him what just happened to him?
That comment was made after we had paused and we had delivered sort of the news, thinking, you know, now we've said everything we need to say, and give him a chance to respond or ask any questions. And I'm sure we even said, you know, do you have any questions? And then some more conversation ensued, and interrupted this time. He looked up and said, "This is the hardest thing you do, isn't it?" And I would have said something to the effect, you know, right now I'm more concerned about you than how difficult our job is. And then he went into a description of, because I used to do this in the Army or the military, I forget which service he said, but I used to have to call and tell little Johnny's parents that little Johnny didn't survive. And I remember how hard that was.
And this comment that you just told the jurors about, was that something directed at you?
Yes, looking straight at me, yes.
About how long do you think that you were in the consult room that we just saw there in 508, having that conversation?
10 minutes, 15 minutes.
And after you leave, does that sort of complete your involvement in this particular case?
Yes, other than documenting in the outnote and things like that, yes.
And after you have this conversation and finish documentation, do you actually leave the hospital yourself?
Yes.
And how do you actually have to go back down to valet to get your car that you left there?
Yes.
Okay. Traditionally, when you come into the hospital in a non-emergency situation, would you valet your car or park in the actual?
No, I would park in our parking lot and walk across, yeah.
One moment, Your Honor. I don't have any other questions. Any redirects?
Stand.
Dr. Sellers. My name is Don Samuel. We've never met before, is that right, or talked?
I don't think so, no.
With regard to the testimony regarding the efforts to save her life when you were in the operating room, there's no question in your mind that the cause of death was a gunshot, correct?
Correct.
There's no doubt that the bullet entered somewhere in her back, correct?
Correct.
And then caused a great deal of damage, correct?
Yes.
And did I understand you to say that it hit a bone or the bone to the side of the vertebrae and changed course at that point? Was likely to have changed course, the bullet changed course, and then exited out the front, correct?
Well, from what we saw in the operating room, I couldn't tell if the trajectory had changed, but I could just tell that it had gone through the bone, yes.
Okay. And I thought when you were asking the assistant DA questions, you said when a bullet hits bone, it is likely to have changed course or will change course.
It certainly can, yes.
Say it again?
It certainly can, yes.
Certainly can. Okay. And in reviewing, what you said before to the DA, when you were interviewed earlier and your testimony here today, there were great efforts made by the doctors to save her life, were there not?
That's right.
Both you and your colleague, Blaine Saeed, correct?
And multiple people prior to his involvement, yes.
Okay. I mean, we can call it heroic, we can call it great, but it was absolutely fine care, was it not?
As far as I can know, yes.
When you left the operating room and you went towards the room that went to the consult room, there's a consult, a family room downstairs in the ER, correct?
I don't know that, probably.
Okay. And then there's a family room up on the OR. It's kind of the same, the rooms where families sit, correct?
Again, I'm not familiar with the ER arrangement, but certainly in the operating room, yes.
That's what I'm talking about, on the third floor.
Yes.
Okay. And at around 12:45 or shortly thereafter, when you leave the operating room, you're still wearing scrubs?
Yes, I would have been.
Okay. And we've all watched TV. I assume everything else about TV is wrong, but at least the scrubs look like they do on TV, correct?
Blue scrubs. And honestly, there was enough time I can't imagine this would have been the case, but I would have driven in jeans, and I don't think I would have. There was enough time that went by to where I could have changed, but I'm pretty sure I would not have done that. That wouldn't have been professional.
And when you meet with Mr. McIver and the person he was with, Mr. Maples, is that correct?
Based on things I've learned, I guess maybe between then and now, I would think that's who that was, but I'm not specifically. I don't remember he introducing himself as, I don't remember the name he used when he introduced himself.
That's not important. That person didn't coach Mr. McIver or tell him what to say or really have any input, correct?
Correct.
At all?
Correct.
He didn't say, this is what I want you to tell the doctor, or this is what I don't want you to tell the doctor. He was just standing there with
Not in my presence, correct.
and then the chaplain was there, correct, Rhonda Jones?
Yes.
Did she come up the elevator with them, or was she with you waiting for them, or you just don't?
I don't recall, unfortunately. Yeah, sorry.
So, and I know this is probably speculation, maybe I'll get an objection, but when Mr. McIver saw you, do you think that you all have a demeanor and, I guess, some bad news for you?
Without their perspective, it's hard to know. We certainly aren't jovial. I mean, it's...
You're not coming up like this, coming down the hall like this.
No, for sure.
Right?
Yeah.
And I didn't mean that.
Yeah.
It could very well have been the case, based on the way you approached them and talked to them. You need to have a seat. He knew it was really bad news.
I'm going to check speculation here.
I think it's a fair question.
It's fair, but it's also asking him to guess what folks might have been doing. That's the kind of thing you're free to impart to the jury later.
Yeah. Look, let me ask it to you this way. Without trying to probe what's in someone else's mind, is your demeanor such that a person could come to the conclusion, I'm about to get some really bad news? That's not
I'll allow that. That's as far as we'll go with this.
We try not to telegraph anything. I mean, I'll say, and the gesture you used a minute ago with your thumbs up, when someone's coming across, in a usual morning, room full of people in the waiting area, and the family member gets up, way away from you, and they're walking your way, if things have gone well, I'll do that. That way, that, extra 20 steps, they're not worried to death. Clearly, we wouldn't have done that, but we were waiting in the room when they arrived, so there wasn't an opportunity to telegraph a message one way or the other.
I'm curious, when the encounter with Mr. McIver and the other people and the other person ends, do you leave or they leave? Is he given? Let me. If you don't know, well, go ahead and answer.
I don't specifically remember if I would guess what normally happens is we leave the room to let them sit with the chaplain and, yeah.
Do you know whether he was then allowed to go visit with the decedent?
I've heard since then that, yes, but I wasn't aware at the time.
With the chaplain? The chaplain escorts him into the operating room and he's allowed to just sit there for a while?
I don't know the details of those events, no.
You learned that that's a typical thing and you learned it did happen here?
Yes.
You indicated that it's not often that someone dies in the operating room, is that right? So you don't often have the burden of doing what you had to do that evening in the consult room?
Correct.
But you do know that people react differently, correct?
Within standard deviations, yes.
Okay. Not a mathematician, but I'll accept that. Even the exact same circumstances with different people would react differently.
Well, no two circumstances are exactly the same, so it's hard to it's hard to say.
Even if there was very similar circumstances, two people might react differently.
Again, no two specific reactions are the same, and no specific circumstances are the same, so it's hard to say.
Okay. If someone is the survivor of someone who died of cancer, for example, after a long illness, that's one circumstance, right?
Yes.
Another circumstance would be someone who is the survivor of someone who dies in an unexpected accident, dies suddenly, right?
Correct.
And those people might react very, very differently, correct?
Yes.
And probably a very unusual circumstance, maybe one you've never seen before, would be someone who is the survivor of someone who died suddenly, and that person was at least part of the cause of death.
Well, I'll say there are some.
I'm going to object to speculation as to this line of questioning. I think he's answered it to the best of his ability. Speculation.
I'm okay with the question. You can keep answering.
Well, I was going to say there's some components of a tragic loss that are common across the board, across the spectrum. Whether it's someone that died of 5 years battle with cancer versus someone that just died in a car wreck. So there are some things that are common to all, I think, grief, and some things would be situation specific.
Well, but the circumstances of someone dying suddenly and unexpectedly would clearly be different than someone who dies after hospice care, right? Or in hospice care.
I don't disagree with that, sure.
And you learned, I guess, from talking to the brief conversation you had in the consult room that Mr. McIver had been in the military, correct?
He said that, yes.
And told you about the experiences he'd had having to do, at least to some extent, the same thing you were doing, which was telling people about the loss of life.
He was recounting that and how it affected him. I don't remember him saying or his saying anything about how people reacted.
I didn't say that.
Okay.
I said he was recounting how he was doing essentially what you were doing just then, telling survivors about the death of a loved one.
Okay. Yes.
Correct?
Yes.
Okay, Mr. Conner, you could keep this super on point. That would be great. We might be able to get the doctor out here before we have to break for lunch.
Dr. Sellers, you just told Mr. Samuel that there are some things that are consistent, that are sort of universally consistent with grief. There are some similarities there for all those experiences.
Yes.
Did you observe any of those things that you would say are universally consistent with grief in your conversation with Mr. McIver?
I did not.
Mr. Samuel asked you about the sort of care that Emory gave and the attempts that you made to save Ms. McIver's life. Tell the jurors, what is a massive transfusion protocol? It's
something that hospitals have in place for circumstances, sometimes in the operating room with unsuspected blood loss, or in the trauma setting where there's, a massive blood loss prior to their arrival.
And the injuries that Diane McIver sustained, are they consistent with, would she have been somebody who needed a massive transfusion protocol there in the emergency room?
Yes, well, a lot of blood available in a short period of time. Yes.
And is a massive transfusion protocol something that happens on a regular basis at Emory University, the Clifton Road campus?
In the emergency room, no, for sure.
Okay.
And the massive transfusion protocol also, in addition to the red blood cells, which is what carries the oxygen to the organs, are other components of blood that are separated and given separately, like plasma and things like that. But
you talked to the jurors. Mr. Samuel asked you some questions about sort of your approach to people in general, but Mr. McIver, sort of how you come into the room. In this circumstance, were you already in the room?
we were in the room already.
And that's when you first came into contact, or when Mr. McIver would have first seen you?
Yes.
And so there were not two surgeons in scrubs and a chaplain coming around the corner walking towards Mr. McIver?
Correct.
And did you ever see Mr. McIver sort of look behind him to see who you were talking to at any point?
I don't recall that, no. There was no one behind him.
Did he ever ask, or did anybody ever ask him about seeing a chaplain, or was she already there?
She was there.
I don't have any other questions.
Jurors, if you have questions, ask them to the left and down. Deputy Murphy will collect them.
Is this mine?
Doctor, did you, during any part of the work you did to try to save Mr. McIver, find the bullet, the projectile?
I did not.
Are you able to explain to the jurors how there could be an entry and an exit wound, but not much visible external blood loss, if that makes sense? In other words, you found lots of blood, but if the evidence is there wasn't a whole lot of blood in the vehicle where the shooting happened, et cetera, how could that be?
Sure, yeah, good question. The injury would be to the blood vessels would be maybe halfway between the front and the back. And the track is really small, and the soft tissue will fold in or close in on the track. The abdominal cavity is pretty capacious and can expand and accommodate the blood, so the path of least resistance or the pressure inside the abdomen wouldn't be enough to overcome pushing blood through those long tracks that were occluded by the soft tissue that falls in behind the track. So that's not surprising to me at all.
While you were working out of state or at Piedmont, did you ever perform any gunshot trauma surgeries akin to what you were doing on the night in question?
Nothing related to a gunshot. I will say that the training we get in transplant surgery means that transplant surgeons get to this part of the body more than anybody else, even more than trauma surgeons. And the reason we do that is because it's a integral component to doing an organ procurement. So if you're going somewhere to take a liver out or kidneys out to be transplanted, you have to put the clamp on the aorta where we put our clamp. And because of, I've done that 1,000 times, if not more. So because of that and our familiarity with doing that, we were able to do that as quickly as anyone could have done, I think.
During your consultation with Mr. McIver, did he ever ask you why Ms. McIver couldn't be saved, the medical reasons behind it?
I don't remember that question, no.
During your consultation with Mr. McIver, did he ever offer to you any description or explanation of what led to Ms. McIver receiving the gunshot injury?
No.
You described another gentleman accompanying Mr. McIver for the consultation. Did that person ever ask you any questions, or your colleague any questions?
Not that I recall, no.
Ms. Convery, any follow-up for Dr. Sellers?
No, yeah.
Mr. Samuel? No, Your Honor. All right, Doctor, appreciate your time. You are free to go.
Thank you.
Ladies and gentlemen, we're going to break for lunch. I got the note that you all have time constraints that keep you from staying late this week. Fully respect that, and we'll work with that. Do we still want to do the 45-minute lunches, or after a few weeks of that and losing too much weight, you want longer lunches? We're good with 45? Let's try to be back then at 1:15 to see if we can get going with the state's next witness at 1:15. Thank you for your time and attention. Enjoy lunch. There's supposed to be a big rally going on up at the Capitol. If you want a little diversion, you can go there. And we'll just make sure you come back at 1:15. Get swept up in the cause.
All rise for the jurors. Please be seated.
Mr. Rucker, anything from the state before we break? No, sir. Mr. Samuel? No. Okay. Let's be back a little before 1:15. Thank you.
Non-court staff, if you can go ahead and exit the courtroom for us now, we will appreciate it. We will be back at 1:10.
Are you doing text?
It's the beginning. Yeah.
Yes.
But you can't hear it.
I like this curious. Click me,
That's what I'm